Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks.
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud BMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Oh, yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
there's more. Go ahead.
There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who as far as I know, actually exists, but I don't have any evidence to that effect. Has not appeared in any hearings in this court. Did not appear for her deposition that she was noticed for in the federal case. And in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your
Yeah,
Honor,
go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor.
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights?
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and
No,
then
I have
you
a
can
lease
go
with
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction, so I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay,
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know.
communicating with
I don't know
Remax.
that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did, the,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I could deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract,
Mhm.
but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond, I would set at this time at a rental rate or a rate. And I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you,
Okay.
Your Honor.
Thank you.
I know, you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's in recess.
All right. Peace, man.
It should be in the 10 o'clocks.
Do you have the 10 o'clock still on there?
Yes, I do, Your Honor. So
Mr. 2500260.
Yes, Your Honor.
Good morning. Your
Good
name?
morning, Ramsey Swedan.
For some reason. So you hired an electrician.
Correct.
That was to be at your residence at 27229 Jessica Lane,
That's
right?
correct.
You did not properly perform the services.
Correct, Your Honor.
I can't read this, failed to, it's just kind of, the type is a little very light.
No
He
problem.
failed to appear on numerous occasions to perform such services.
That is correct, Your Honor.
Failure to appear caused me to lose work, leave work, resulting in loss of profits. What does that mean?
I own a staffing business and I leave my,
I can't give you a loss of profits.
I know, we were actually in front of you already and, the judgment was on your end. You, gave me 2,800 and some odd dollars. I can't remember the back end of it. However, Mr. Byers made payment.
I believe it's a discovery. There should be a copy of the discovery subpoena towards the back.
Thank you.
Sorry about that.
Not a problem.
Okay, so this is all right. Yeah. Try to get that in the front. I see. So you issued credit, this is for a creditor's exam that was scheduled for 8:30, right?
Correct, Your Honor.
Defendant failed to appear. So unfortunately, the process is that we have to issue a show cause. If he doesn't show up, I'm gonna issue a warrant for his arrest, okay?
Sounds like a good idea.
So issue show cause. You go down the hall, fill out the paperwork. We'll give you a date. Unfortunately, this is the process and it's gonna take a little bit of time, but we should be able to schedule that for you in the next 3 weeks, okay?
No problem. If you don't mind, put on the record, he hasn't made one single payment.
Did I, wait a minute, let me check something here.
Judge, there was alternate service ordered on it.
I understand, but
Okay.
was judgment, did the judgment provide for, I don't have a copy of the judgment in here, at least I don't
I
think.
apologize. Maybe I misprinting that
So-
when I was,
Do I have, can you tell me whether the judgment indicated had an installment payment plan?
No, it was a default.
I see. So he didn't show up for that either, huh?
Oh, no, I apologize. It was after trial, but he did not, there was no payment order on it. I'm
Okay,
looking at the
so-
original.
So we'll issue a show cause.
Thank you, Your Honor.
You're gonna have to fill out the paperwork, okay?
Not a problem.
All right,
Thank you.
have a good day. Sorry to keep you waiting again.
No problem, Your Honor. Thank you.
JP Morgan Chase versus Mark A. Dixon, 250534. Good morning, everybody. Mr. Dixon, your name?
Mark Dixon. Good morning, Your Honor.
Do I have Mr. Jamal out there somewhere or somebody from that office?
Mr. Katz, give me 1 second. Let me see.
Your Honor, Andrew Cates, P78292 for JP Morgan Chase.
Good morning to you. All right, so. Well, there wasn't much of a motion filed. Mr. Dixon, you can go ahead and proceed. All you have on here is to dismiss case and to compel private arbitration. Jen, I don't know if it's just my eyes or we need to get your, what do you call it, more toner in there.
It's my printer.
It's bad. I cannot read this.
Okay.
Mr. Cates,
Yes, Your Honor.
what do you think about his, you agree with him, right? I mean, I can't read this, but I trust that.
You know, Your Honor, a lot of these contracts have a arbitration clause that makes it available, so I have no objection to the arbitration motion this morning.
How much is this debt over?
The amount
88.85?
88.85.83 plus requested court costs and fees.
I got it. Okay. I'm gonna need, will you prepare an order for me, Mr. Cates? Just indicate upon Mr. Dixon,
Yes, sir.
you're not gonna have to say much here, okay? I don't mean to steal your thunder if you wanted to play lawyer today, but I'm just gonna go ahead and indicate that the case is dismissed without prejudice for the reason that the parties shall proceed to arbitration in accordance with the arbitration clause in the agreement, okay?
Thank you, Your Honor.
Counsel, will you submit an order to that effect for me?
Yes, Your Honor.
All right, anything else, Mr. Dixon? You understand what's going on here?
Yes, sir. Thank you, Your Honor.
You're welcome. Good luck. Thank you, counsel. All right. JP Morgan versus Susan Swaffer, 2501097.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
Good morning, counsel.
Good morning.
I have Susan Swaffer. Is she out there?
No, good morning, Your Honor. Matthew Langston, P7983, appearing on behalf of the defendant.
I see. Okay, I do have an appearance. All right, so you guys are here for a pretrial. Any resolution on this?
Not as of yet, Your Honor. I believe that defendant has a debt settlement company involved, and there have been talks, but no settlement as of yet.
That is correct, Your Honor.
All right, so I'm going to go ahead. All right, so I have, just give me 1 second if you would, please. That is 49102, right, counsel, Mr. Royce?
Yes.
And then Mr. Langston, you have 79838.
Yes.
Do you guys want discovery? If so, I'm not, it doesn't sound like there's any dispute here.
Yeah, we typically request 60 days and
All right,
that's
good.
really more.
I don't have a problem with that. Is September 15th a weekday, Jennifer?
It is a Monday, Your Honor.
All right, so I'm gonna make September 15th discovery cutoff. No motions heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. I'm gonna go ahead and say that witness lists are due by August the 15th. I'm putting down 1/2 hour for trial. Nobody demanded a jury. We're gonna give you a trial date, so I'm gonna ask you to get your books out. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. And what do you have, Jennifer? I'm thinking like
Late October, early November,
late October.
the 20th,
October 20 at,
10:30.
is that good with you, Mr. Langston?
You said October 20th, Your Honor? At
Correct.
10:30? Yes.
Mr. Rice?
Yes, Your Honor.
October 20th at 10:30 will be the trial date. We will prepare the pretrial order. Does anybody have anything else they need to say?
No, thank you, Your Honor.
Mr. Langston?
No, Your Honor. Nothing.
All right, have a good day.
Thank you, you as well.
Thank you, Judge.
All right. Is Mr. Pallets out yet or not, Jen?
No, yes, they are.
All right, let's call that one GTSC Warehouse versus Christopher Anthony Adkins, 2404976. Mr. Adkins, your name?
Christopher Atkins.
Good morning, sir.
Good morning, sir.
Ms. Kuzi?
Well, Your Honor, Sanjay Kuzi on behalf of the plaintiff.
It's like the koozie that you put a pop can in, right?
Yes.
Okay, how are you? All right, so did you guys resolve this?
No, Your Honor, we have not resolved this. We did have a chance to speak in a breakout room, but there has been no resolution as of today. The last time we were present was on June 17th, and this court did adjourn the scheduled conference. And in the meantime, our office did file a motion for summary disposition, which my office doesn't intend to proceed with that today. The defendant did indicate that he is intending to file bankruptcy, which is also what he had stated at the
He's
last
intending to file what?
bankruptcy, and we did confirm that he has not yet filed bankruptcy. But he says that he doesn't indicate that he's intending to do so, but as of today, there has been no bankruptcy filed. He does not dispute that he does owe a balance that's due and owing, and that there is no valid defense to his claim. There's past due balance since the date of June 2024. My client has not received the payment per the promissory note security agreement, so plaintiff would be seeking to request possession judgment. And this is not it's a possession only action that we had filed. So we would be just seeking to proceed with that.
Sir, you don't want to talk to a lawyer?
Your Honor, I have, I sent him my class. I had to take a class for my bankruptcy. I signed my papers tomorrow. I called them on the side when we were in our breakout room to see if he already filed, because I submitted my paperwork to him last Tuesday. And I didn't know, he didn't tell me to come down and sign yet. That's the only thing that stopped me from actually having a case number.
Counsel, do you have any objection to an adjournment of this for a week?
Yes, I do, Your Honor. Since we were present the last hearing on June 17th, when he stated the same thing. And that is why the court did adjourn the matter, to give him the time to speak to his bankruptcy attorney, to file any documents that he needed to. And he did confirm at the last hearing that the bankruptcy attorney is not representing him in this matter, and that he is not being represented by an attorney. He's had the time to do so, and it's been a month now. So plaintiff would be requesting to proceed with the judgment. This case was filed in December of 2024, and it's still pending as of today. My client has not received any payments, and there's no dispute that he owes that amount. And his only defense is
good.
And as stated in his answer, his only defense is that he said he's been off of work. He said he's an injured veteran, but Your Honor, there's no other valid defense to his dispute. There is a contract that he has breached at this time, and plaintiff would be requesting a possession judgment to allow our client to proceed to give possession back to them.
Okay, Jennifer, would you tell me, do you have the attached proposed order? They referred to it in their motion for summary. I don't have a copy of it.
Okay, I can look real quick. We would have it in the pending. Sorry, Judge, computer decided to be a little slow at the moment.
Let me go on to another case. I will come right back to you. And you
Judge,
guys,
I
if
do
you
have it.
find that, Jennifer, bring it
I
down.
do have it,
somebody-
Judge.
Will you please?
Yeah, I have
All
it.
right.
I can send it to your signature box, or do you want it printed?
I want it printed.
Okay.
Crown Asset versus Lori Todd. Crown Asset versus Lori Todd, 2501387.
Good morning, Your Honor. David R. Monroe, P18081. Appearance counsel.
Morning, counsel. How are you? It's
Very
nice.
well, thank you.
It's nice to see somebody has a P number that's lower than mine. You know what I'm saying? So, at
That's
any
an old
rate,
one.
do I have Lori Todd here?
No, Your Honor, she's not appeared on Zoom.
Counsel, you want to go ahead and take a default?
I would, Your Honor. I would like to mention in passing that the answer to this complaint, the defendant admitted everything that was alleged in the complaint. So,
Yeah. Well, she's not here. You can give me your breakdown if you would, please.
okay. They sent me a very skinny file, Your Honor. And I don't have a proposed judgment.
Well, it
in
says that the amount owed is 346805.
That's correct, Your Honor, and I don't know about service fees. I assume there's a filing fee.
I got a service fee of $54.40, it appears. I got a filing fee of $75, it looks like. And you're entitled to your statutory attorney fee of $75, so that's $194.40 in costs. And so unless you have something else, it should be 36, 62, 45. That's what I'm coming up with. If you disagree, please tell me.
Works okay with me, Your Honor. Can I have them send you a 7-day order?
You don't have to send a 7-day order. Just email it, file it today, and I'm going to sign it today. He didn't show, she didn't show up. Defendant was, this case was scheduled for 8:30. It is now 9:23. So you can just send an order over to Jennifer there and I'll get it. They'll review it and I'll sign it. Okay?
Thank you very much, sir.
Have a good day. Thank you. Nice to have you here.
Thank you. Bye-bye.
All right. Did you bring that in?
Sure, right there.
Wait a minute, where? That isn't it. Oh. Stuff. All right, recalling GTSC Warehouse LLC versus Christopher Anthony Adkins, 2404976. Counsel, your appearance again.
Andrew Creasy on behalf of plaintiff.
Mr. Adkins, your appearance again.
Christopher Atkins.
Sir, I'm sorry. I'm going to go ahead and grant their motion. You didn't provide a response, and everything appears to be in order, so the motion for summary disposition is granted. I'm signing your order, counsel, and we will send that out to you however they do it. Okay? Thank you. Have a good day. Good luck, Mr. Atkins. What?
Our office will also submit the judgment, which will also just.
Yeah, send that over. Thank you.
Thank you.
Thank you very much. All right. Now what? Michigan Legacy Credit Union versus Tyler Ryan Hurd and Michael Wayne Howling, 2501458.
Good morning, Your Honor. Terry Weishaus on behalf of plaintiff P86739.
Good morning, Ms. Matt. Mr. Hurd, are you out there?
Yes, Your Honor. Tyler Hurd.
Okay, I'm gonna need your face in there, not a picture, okay?
Yeah, I'm trying to get
Take your
going.
time. Take your time. Tyler Hurd. Where's Michael Howling?
I don't know.
Your Honor, he has not been served at this time, and I do believe we might even have to restart his case if he hasn't been served by the time the second summons expired.
All right. They filed a motion for summary disposition, sir, Mr. Hurd. They're asking for $12,918.64. You did not, it appears, file a response. Is that true?
Yes.
You did not, correct?
To my knowledge, yes.
Well, you would know if you filed one, right?
Yeah.
Okay. So let me just ask you this. Do you have any defense here?
The best. No, not really.
Your Honor,
Yes.
Your Honor, if I may, I believe that the MSD motion is being heard on July 29th.
Oh.
Yes, Your Honor. Today
Yes.
was just the pretrial.
I'm-
There
my-
wasn't enough time, I think, when the MSD was filed to add
my
it to today.
apologies. If you guys want to go into a breakout room, see if you can resolve this, set up a payment plan. Mr. Hurd, listen, if you owe the money, it's not going to do anything to benefit you by prolonging this. Maybe you can talk to Ms. Wisehouse if you acknowledge that you owe the debt and set up a reasonable installment payment plan that the two of you can agree upon. Okay?
Yep.
And fair enough. So we put you in a breakout room and then you can chat with Jennifer and let me know when you're out. How's that?
Your Honor, we actually did speak earlier in a breakout room, and it was a fruitful discussion. I don't think that we have a set answer today, but I'm optimistic that we could probably be submitting, e-filing a judgment very soon and before the MSD motion.
Well, let's do this. I don't see any reason to conduct a pretrial. It sounds like you guys are right there. I'm just going to adjourn pretrial, set motion for summary on the same day. We'll just keep it on the same day, which will be July 29th, and that will be at 9:30. And sir, if you have a response, you can file a responsive brief. If you disagree with the amount and think that you don't owe the debt to the extent that they do. Okay, so that's what I'll do. We'll keep it on. Jennifer, I don't believe I had a copy of that other than what's in there, so I'm going to need a copy of that before the 29th. Anything
Yes, Your
else,
Honor.
Wisehouse?
No, Your Honor. Thank you.
Mr. Hurd, anything else? Any questions, sir?
No, Your Honor.
I wish you well. Good luck. We'll see you guys on the 29th, barring a judgment coming forth, okay? All right.
Thank you.
Thanks a lot. Do I have Midland Credit versus Diane Taylor? 240427 GC.
Yes, Your Honor. Violet Osk on behalf of Midland Credit Management. This was originally scheduled for 9:30, but I do have another case before you that was scheduled at 9 with Miss Tiffany Jin. If you could maybe call that, we've been
I'll
waiting.
call that and then I'm gonna give them 15 minutes. This is Midland Credit. Do you have that? Hang on a second here. I'm losing. Where are all these files? Midland Credit versus Tiffany Ginn, GINN 2404225. All right, your appearance?
Violet Oscona on behalf of the plaintiff, Midland Credit Management.
Is Jen, your name, ma'am?
Tiffany Ginn.
Good morning to you, ma'am.
Good morning.
So, counsel, you can go ahead and proceed with your motion. I did not receive a response from you, Mrs. Ginn, so you can go ahead and proceed.
Actually, the defendant entered into a payment plan with us recently. And if I may, I would like to put the terms of the payment plan on the record.
Well, do I have a judgment?
No, there is no judgment.
Well, we're gonna have to do a judgment, right?
Okay.
Okay, so you guys probably are going to want to enter into a consent judgment
Yes.
and then with payment terms in it. And if you do that, if maybe you can go into a breakout room, formalize all that, we'll go back on record, and then you can put the terms on record. Is that fair, Ms. Osco?
Yes, we were actually in a breakout room earlier. And that's what I would like to place on the record is the consent judgment and payment terms.
Oh, okay, go ahead. I'm sorry, I misunderstood. My apologies.
That's quite all right. So the defendant agreed to pay $584.34. The initial payment was made last week in amount of $5. A recurring payment.
Wait a minute, the amount of $5.
Well, yes, initial payment.
Hang on, let's slow down. What is the total amount of the judgment that everybody agreed upon here?
$584.34.
Okay, that's the judgment amount. That's okay. Go ahead.
Yes. Initial payment was paid last week in amount of $5. There are reoccurring payments in the amount of $116 beginning July 24th, 4 biweekly payments of that amount, and a final payment of $115.34 due on September 18th of this year.
How often are the payments to be made?
4 biweekly payments in amount.
I see. So I want to make sure I have this correct. You got a judgment amount of $584.34. She paid $5. So why don't we just decrease the judgment amount to $579.34? Then she's going to pay $116 payments biweekly commencing July 24th and every other week thereafter, with the final payment, I think you said, of $115.34 that will be due on September 18th. Is that true?
Yep, that is true. Yes.
So let's just decrease the amount of the judgment to $579.34. Do you agree with everything that was just said, Ms. Ginn?
Yes, I do.
Does she have your permission to sign your name to a proposed consent judgment that says that a judgment will enter in favor of the plaintiff against you in the amount of $589.34 with the further provision that you're going to pay $116 beginning July 24th and every other week thereafter, with the final payment due on September 18 of 25 in the amount of $115.34?
Yes.
Does she have your permission to sign your name to a proposed consent judgment to that effect?
Yes, she does.
Do you have any questions for me at all, ma'am?
No, Your Honor.
Anything else, Ms. Lasko?
No, that is all, Your Honor.
Have a great day. Thank you. I await your judgment. Thank you.
Thank you.
All right, let's see, is there a, all right, I'm getting ahead of myself here. I'm going to go Kyle Marcus Brown. (25T644492A). Your name?
Kyle Marcus Brown.
All right, listen, what brings you here? On May 14th, you were here.
Yes, sir.
First, I gave you till April 18th.
Yes, sir.
Right?
Yeah.
To pay all of it.
Yeah.
You didn't pay it.
No.
You paid $25 May 5th, right? right? Right?
Yes.
You gotta answer out loud.
Yes, sir.
And then I extended your time until May 28th, right?
Yes, sir.
And I told you if you didn't have the money May 28th to come talk to me, did I not?
Yes, sir.
Just like I told you on the date of that I entered the judgment, that if you didn't have the April 18, 24 payment, you needed to come talk to me, right?
Yes, sir.
And now here you are 2 months later, and you're asking for time to pay, right?
Yes, sir.
What are you doing? Come on, show a little respect. How much do you have today?
Today, I don't have none. I lost my employment. so
Why?
it's kinda,
Why'd you lose your employment?
Just multiple reasons.
Are you fooling around at work?
No. Point, yeah, I worked on the week where I worked at, I was a point system, so I pointed out.
Did you get fired?
Yeah, for too many points.
Miss work?
No, I wasn't missing work.
Late for work?
Yes, sir.
Why are you doing that?
I have no insurance, so I couldn't drive my car, so I had to catch Ubers to work, so it was like,
Now you're in a bind.
Yeah.
Are you working now?
No, I have a job interview, later on this week,
Where?
at, this place out in Boston.
Listen, you gotta be a little more responsible. It's your life. How old are you?
Yes, sir.
How old are you?
34.
All right, you gotta be a little more responsible. You pay $25 per week. I'll give you some leeway time. You need to come and talk to me though if you don't have the money then, okay?
Yes, sir.
I'll start you on August 15th. Is that enough time?
That's perfect.
Now, if you don't have the money, what are you gonna do?
Come see you.
What if you don't have it, what if you have it on August 15th, but you don't have it on August 22nd? What are you gonna do?
Come see you.
What if you have it on August 15th and 22nd and 29th, but you don't have it on September 5th? What are you gonna do?
Come see you.
See how easy this is? Good luck. Thank you.
Yes, sir.
All right, have a good day. Good luck.
Thank you.
What else do I have? Discover Bank versus Michael Curtis. Discover Bank versus Michael Curtis, 2500901. Michael Curtis, is he here? Anybody here for Discover Bank?
Yes, good morning, Your Honor.
Okay, Mr. Duquette, your name?
Thomas Duquette, P82958, on behalf of the plaintiff.
And this is for a pretrial, and Mr. Curtis did not show, correct, Jen?
No, I'm here.
Mr. Curtis is here.
I'm here.
You gotta start your video, sir.
Sorry about that, Judge.
That's okay. Do you owe your debt, this debt?
Yes.
Do you want to go into a breakout room with Mr. Duquette and see if you can resolve it and set up an installment payment plan?
I've actually been with a credit consolidation firm for a couple years, sir, trying to get this debt knocked out. So that's what we just were talking about before we started.
Has anybody contacted your office from this credit settlement company, Mr. Duquette?
Yes, we have heard from them. It looks like they made an initial settlement offer, and that process is ongoing. They're
When was
working
that?
towards a resolution.
When'd you hear?
The most recent communication occurred back at the end of June 24th, it looks like.
Was that, how many communications have they had with you or your office?
Since the filing of the suit, it looks like just the one.
Yeah. I mean, if you hired them 2 years ago, they filed the complaint March 3rd and we only heard from them, they only heard from them in June. It doesn't bode well. Look, does anybody need discovery? I don't care to, why perpetuate this? Why don't you just file your motion and we'll move this on. I'll give you a trial date.
If the court wants to set a motion for summary date, that would be perfect.
All right. I'm still gonna fill out a discovery order. What's your P number, counsel?
82958.
I mean, it's a 82958. I mean, it's,
Right.
I misspoke. I meant a pretrial order. All right. Notice, I'm just gonna say discovery none permitted. No motions heard date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. If it does go to trial, you don't have to file a trial brief. But if you choose to, you can file and exchange it not later than 7 days before the trial date. Nobody demanded a trial by a jury. We're not going to have a settlement conference since there is no jury. Everybody has to file a witness list. I'm going to say by August the 15th. Jennifer, give me a,
September date?
yep, latter part of September, trial date.
Okay, September 30th at 10:30?
September 30 at 10:30 will be the trial date, okay? And I'm just going to indicate no discovery permitted. I'm going to encourage both of you to read this pretrial order, and you'll, I think, get the gist of it, all right? There's other things I'm just not going to go through. Anything else?
No, that's all, Your Honor. Thank you.
Thank you very much. Have a good day.
Likewise.
Thank you, sir. All right, Active Life versus Allstate. 2501621.
Good morning, Tony Blackburn here on behalf of Allstate, or on behalf of Active Life, sorry.
Morning, Your Honor. Zara Miller on behalf of Allstate.
All right, just give me 1 second, you two, please. All right, let me see. What's your P number, Mr. Blackburn, again?
P82871.
I'm sorry, say that again?
82871.
And Ms. Miller, yours is what?
P87552.
I shouldn't ask those questions. All right, you guys want discovery for a while?
Yes,
Your Honor.
How long?
60
90
days,
Or
90 days.
60 days. Yeah, 90 days.
Okay, good enough. I'll give you 90 days, given the nature of this. I'll give you until October the 15th. Did somebody demand a jury trial here?
I believe we did, Your Honor.
Is that true, Jen? Can you look at that and just double check?
I am double checking right now. There was a demand when it, yes.
Good enough. So here's what I'm going to do. There's no ADR. Witness discovery cutoff is October 15th. Witness lists are due September 15th at 25. I do want you to file a trial brief in this case. It has to be filed and exchanged not later than 7 days before the trial date. There will be no ADR, no mediation. We're going to give you a trial date momentarily. You do have to submit requested voir dire questions. You know what? I don't really need those. We're going to take that out. But jury instructions and the proposed verdict form, I'm going to need 7 days before the trial date. And we're going to give you a trial date in November. Do you guys want to go to mediation or anything? Any reason to do that? There's no sanctions anymore, right?
I don't believe that would be necessary, Your Honor.
Good
It's pretty
enough.
straightforward.
Okay, good enough. So Jennifer, give me a date, let's call it in latter part of November, the third week of November.
The 21st.
No, I want you guys to look at your calendars, make sure that you're good that day, because I don't want to have to adjourn this, okay? And we're gonna make it November 21 at 8:30 unless somebody has a conflict with that. Either one of you have a conflict? You muted yourself, Mr. Blackburn.
I do not have a conflict that day.
Ms. Miller?
No conflicts that day, Your Honor.
All right, now let's set a settlement conference date. We're gonna settle this. You can set it anytime before November 7th and after October the 15th. So if you want to go to latter part of October, that'd be great, Jen.
Your Honor, I'm sorry. When did Jen had to go up to the window for a minute? What date did you need in October?
I need a settlement conference date in the latter part of October. They're bringing in the first string now, eh?
How about October 20th
That's fine. You guys good on that day
That works
at
for us, Your Honor.
9:30?
at 9:30?
Yes.
Both of you good that day?
Yes, Your Honor.
Okay, I'm gonna set a settlement conference October 20th at 9:30, trial date November 21 at 8:30. I put down 1 day for trial, witness list due September 15, discovery cutoff October 15, no motions to be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date, and you do have to submit your proposed jury instructions and verdict form not later than 7 days before the trial date. And that's essentially it, except I do want a trial brief at the same time you file your jury instructions, okay? Anything else anybody needs to bring up?
That's all for us, Your Honor.
I think it's covered. Thank you.
Have a good day, you two. Thank you.
You as
Thank
well, Your
you.
Honor.
All right. Where is LVNV versus Neighbors? Let me see. Is that up yet? Or am I getting out of the?
Good morning, Your Honor. Andrew Case P78292 for LVN.
Hang on a second. I need the file on that. Do you have, I just have the motion here. Do you have the LVNV versus Neighbors in it? I'm getting myself on. LVNV versus Kevin Neighbors, 2501911. Okay, I'm not getting a good connection with you, Mr. Gates. Can you state your name again?
Your Honor, Andrew Cates, P78292.
All right.
And good morning, Your Honor. This is Trevor Cruz, P73401. As of this moment, I'm the attorney of record for the defendant.
Yeah. All right. What happened here? Mr. Cruz, Mr. Neighbors is not here, right, Jennifer?
I don't believe so, Your Honor.
There's been a breakdown in the attorney-client relationship. Anything you need to add on that end?
No, I don't believe so.
All right. You do know, because I got this almost ex parte here, you've got to file a motion still unless you get a stip from your client, right?
I mean, I'm showing that I did file a motion.
You did file a motion. It's just that it seemed like it was an ex parte motion where it wasn't scheduled. I could be wrong.
Okay. I'm sorry, Your Honor.
That's all right. Attorney motion to withdraw granted. And you're asking me to stay, I never had a pre-trial on this. So I'll tell you what I'm going to do. I'm going to grant your motion to withdraw. I did not order any discovery or allow any discovery in this case, Mr. Cates. So I'm simply going to adjourn the pretrial for 30 days. If you want to include in there, all proceedings are stayed until the pretrial, Mr. Cruz. If you'll feel more comfortable,
sure.
Covering yourself in that regard, I have no issue with that. Give me another date, if you would, Linda or Jen, in 30 days here.
August 12th, Your Honor, at 10 o'clock.
Yeah, so we'll just make it until August 12th. Well, give me one more week and we'll just be safe. Do you have August 19th or am I gone? I'm gone that day.
Yeah, you're not. Yeah, you're gone.
Let's just make it the 26th. Am I here then?
Yes, you are.
We're gonna make that at 8:30. So, Mr. Cates, we'll send out pretrial notice. Counsel, send that motion to withdraw, stay all discovery and any other proceedings until the date of the pretrial on August the 26th, okay?
Very good. I will get that submitted.
Anything else, either one of you, Mr. Cates?
No, Your Honor, thank you so much.
Nothing, Your Honor. Thank you.
Have a good day, gentlemen. Thank you very much.
You too.
All right, now, are we ready on the small claims case there? Do I have everything? Where's that at? I need somebody to find that case with Zarowski's. It might have been brought down already, I don't know. LVNV versus Nicholas Kearns, 2501648. Do you have it?
I just never given it back.
I don't know where it is. It probably went down the hall. Do I have anybody here on this case? LVNV versus Kearns?
No, Your Honor, I don't believe I've had anyone check in.
And we don't have a judgment on this that was forwarded?
I will double check again.
All right. Jennifer, somehow that case got taken down, Zarowski case. It must have been taken down there. Can you, John's
I
coming?
don't have any down here yet.
Here it
right?
is. My mistake.
Oh, okay.
The M filing, little files all over the place here. Mary Gonzalez versus Dorn and Lisa Zarowski, 2303624. Your name?
Mary Gonzalez.
Your name?
Dorn Zarowski.
Your name?
Lisa Zarowski.
All right. Were there any problems on the creditor's exam?
Yeah.
They answered all your questions.
Yes.
They provided all the documentation.
I didn't look at it, but yes.
Why didn't you look at it?
Well, because I want to expedite this and I severed the tendon of my thumb and I write very slowly now. So just trying to make this a little.
Well, I'm just gonna make a note. The parties were sworn in. Creditor's exam conducted. What are you guys doing? Are you paying? Did you have an installment payment order? Remind me.
We had installed, we were paying our $500 every 2 weeks. And, you know, we were pretty much homeless before August. And then we ended up getting an apartment, which ended up, I had to come up with $3,800 down payment plus the first month rent. So that was almost $6,000. And then it's just, because right now we still pay, right now it's $700 a month just in storage
We were
with our
homeless
stuff.
for 6 months, living in hotels. And so it was like, we just kind of were like falling, you know, paying her and then falling on our face.
All right, let's do this. Who's out there? Jen?
Yes, Judge.
Can you get me an installment payment order? Is there, look, nobody wants people to be homeless here. So why don't we set up a new installment payment order that you think you can make from there? Can you guys talk about an installment pay? It doesn't make any sense to set payments so high that they can't afford to pay it, Ms. Gonzalez.
They offered their payment.
I'm not saying that they didn't or didn't. I'm not saying any of that. I'm just saying maybe we need to revisit in light of where they are.
We made 11 payments on time.
I know you did. I heard that. So what do you want to do? Can you two go sit down and I'll prepare an installment payment order that's acceptable to all? And I say you two, you defendants and plaintiff, come up with an installment payment order that's acceptable to both of you, and I will write it up for you then when you come in and tell me what it is. And then you both can sign it. We can execute a new installment payment order. That's what makes sense to me.
Well, they didn't pay their rent, and when I asked them about paying, they never answered me. When they stopped paying on this, I asked them what was going on, they never answered me. I just feel like that if you feel that's better, that's.
Listen, I've already made clear with the Zarowskis what I feel about how their conduct was here. I think I've made it clear. If I need to do it again, I will, but I don't need to. They weren't truthful. Where are you working now? Both of you?
I work for Rocket Mortgage.
Where do you work?
I have my own company, audio video company,
What's the name of it?
Network One.
Did you get all of that?
Yes.
Yes.
Well,
I offered to come up with a new installment, maybe a lower amount of $250 every 2 weeks.
okay.
And then,
Is that acceptable to you?
Well, I try to garnish her wages. To me, that's a little more stable, that they can't just.
Well, here's what can happen. If you guys enter into a new installment payment order, it's acceptable to everybody. I'll prepare the order. You can double check it, make sure I didn't make any errors, sign it. And then if they miss a payment, you can make a motion, you can file a motion to essentially say, Judge, they haven't paid. Let's set aside the installment payment order and allow me to issue a writ of garnishment on their wages.
Okay, I've gone through that one time already.
I know. Sometimes things, well, look, I get it. You tried to garnish your wages, right?
Yes, and when I sent that paperwork to her, or had it served to her company, they told me they couldn't find her in their system.
Who's she working for?
Rocket Mortgage.
How can Rocket Mortgage not find you in their system?
She told me that. I have no idea.
So that you, I know, but did you serve it? What location do you work in? Detroit?
I work from home, but yeah, Detroit is my office, but I haven't been in the office since COVID, so.
I have 2 letters from them saying they couldn't find her in the system. One that came from ADP, which I guess they outsource all this to, and then another.
I'm telling you what I think you should do, but I don't want to make your decision for you. It just seems to me that if you guys fill out and agree to an installment payment order and with the understanding that if they don't make a payment, you can move to set aside the installment payment order, then you can garnish wages again. You can garnish his company. But it just seems a little bit cleaner. We don't want anybody being homeless. I mean, I don't like the fact that somebody hasn't made a payment and got so far in arrears here, but that's my take on it. So if you guys want to do that, you can. If you guys want, you can agree to it right now if you want. I got an order in front of me I can write. You can go ahead and tell me the dates and how much you think should be paid. Are you saying you can pay $200 bi-weekly?
That's more doable than 500 by weekly, definitely.
yes.
That's my frustration, is I
I know.
contacted them and asked them what's going on.
Listen, you do what you want. I'm not telling you what to do. I understand your frustration. This happens all the time. So you do whatever you want. It's not my decision. I'm just trying to help the situation here. Maybe I am, maybe I'm just sticking my nose in where it doesn't belong. But rather than chasing them around with wage garnishments, this might be.
I'd rather do $250 every 2 weeks. That's $500 a month, and it would be less than 10 weeks. Or
She said we only owe her about 4,000.
Yeah, so that'd be about,
Yeah.
so you're looking at about 8 months. I get it. Right? If they're collecting 500 a month and they owe 4,000, that's 8 months. You tell me what you want me to do.
Okay, we can try that.
Okay, so
I
I'm
have
just,
additional fees that I had to pay for all the getting the process server, filing fees.
well, you're entitled to that. Now, wait a minute. I'm just going to indicate defendant filed the oral motion for installment payments with this court today. You're making a motion to change the installment payment order, correct, Mr. and Mrs. Zarowski,
Yes.
ma'am?
Yes.
Sir?
yes,
All right, now, I'm gonna let you pay $250 every 2 weeks, and you tell me when you're going to start this.
by next Friday.
Yeah.
Okay, so I'm gonna give you until the following Monday. So next Friday is the 25th, so we're gonna make it starting July the 28th, okay? All right. Mr. Zarowski, Ms. Zarowski, don't play games with me again, okay? All right, so I need you This is what I've signed or prepared on the order. I'm gonna need you both. This state court administrator's office form does not have signature lines. I'm drawing 3 lines. I've got 3 X's here. I'm gonna ask the plaintiff sign on the top line if you agree to this. And Mr. and Mrs. Zarowski, you can sign right underneath it. And then you're gonna come back in front of me and I'll have you out of here in about 10 seconds, okay?
How do I add this additional?
You can just, actually, you know what? How much more are you talking about?
$177.
Well, you just send a notice to the Zarowskis. You file with the court. These are additional expenses that have been incurred by me. And you add it to the judgment amount, ma'am. Are you listening?
Yes.
So you're gonna add it to the judgment amount. We don't need to do a new judgment. You don't need to be burdened with that. But if they owed you $4,000 and you got $180 worth, just say, you send a notice a letter to Mr. and Mrs. Zarowski or an email that you copy with the court. I incurred the following expenses, put in what the expense was, the amount is to each, total it up, and say your judgment amount now is. Okay?
We just fill out a form that has that final amount and then we all sign it out.
I don't care, whatever you guys do, just so everybody understands and agrees, all right?
Thank you.
Okay, so you're gonna,
I sign on the top one.
you sign on the top line and Mr. and Mrs. Zarowski are gonna sign on the bottom. Folks, I hope you've learned your lesson. Don't lie to me again, okay? We understand one another?
Yes.
Ma'am? We understand one another?
Yes.
Okay. All right, let me take a look at that. Ms. Gonzalez, I hope you're not doing anything you don't want to do here.
I'm just, like I said, it's.
You're leery. I get it. I don't like to see people homeless either. You know what I'm saying? I mean, I would have modified that order if I'd have had that come to my attention and made it less than 500. And I understand that they agreed to it, but sometimes things change, right? Sometimes. So I'm not blaming you in the very least. I'm just telling you, I think this will work out better for you. Good luck. Thank you both.
Thank you.
All 3 of you, I should say. Good luck. Okay, go down the hall and we're going to give you a copy of the order. LBNV versus Nicholas Kearns, 2501648.
Judge, we've put a call into plaintiff's office. We have not heard anything back yet. Defendant is not here either.
And we don't have a judgment?
I don't have anything in our review that has been filed, correct?
All right. Citibank versus Kimberly Matthew, also known as Kimberly Reed, 2501721. Ma'am, your name?
Kimberly Matthew.
And who is here for the plaintiff?
Andrew KHP 78292 for Citibank.
I'm sorry, I'm just not getting a very good connection here.
I'm in the hallway. Hold on just a second. I'll be in a
Why don't you
second.
walk in here? That'll be easier. You're in our hallway?
Yes.
That's weird. Come on in. Boy, I thought he was in Iron Mountain. Now, you're just standing in for these guys, right? You didn't drive here from Grand Rapids, I hope.
No, I'm a fill-in attorney. I realized that I had a 10 o'clock in front of you this morning.
No problem. Okay, Ms. Matthew, your name again.
Kimberly Matthew.
Did you talk to Ms. Matthew?
I did, Your Honor. Actually, strange turn of events. I think something got lost in the shuffle. Miss Matthew has actually settled this case with our firm. She virtually signed the closing documents. So I would just ask that the court give us maybe a week to get the closing documents in. I'm hoping to have them to you today.
What is it, a judgment or a conditional dismissal or what?
Miss Matthew might have a little more.
Here's what I'll do. I'm adjourning this 2 weeks and I'll trust that you'll get the paperwork in. Do I have July 29th available?
Yes, Your Honor, and we can go ahead and just put that at 8:30.
Okay,
And if the closing documents are submitted, then.
Yeah, you don't have to show up, as long as you get the dismissal order. If you don't get the judgment or conditional dismissal, whatever it was, if you don't get those by the day before, you should make sure you show up on the 29th, ma'am, okay?
On the 29th.
At 8:30, but I'm
I
assuming.
have all my papers.
Okay, well, I just don't want anything to happen. You're probably going to get a dismissal order before then.
Okay.
Or a judgment, whatever. I don't know what you guys executed. I'm not sure Mr. Cates knows either, okay? I doubt you'll have to show up, but I have to get this, sign it. I don't want you to not show up and me not have paperwork and me enter a judgment. That's all.
Work.
What's that?
It's another day off of work. I didn't want to have to take another day.
Well, Zoom from work.
I can't.
Well, I'm sure that he's going to get the paperwork. You're going to try to get the paperwork.
Yeah, I'm going to try to get it done today.
Yeah, she's going to get it done today. I doubt she'll have to show up, but I don't want to be the one responsible saying, don't show up. I don't have paperwork. I enter a default. You know what I'm saying? So, but you should have it long before then, Ms. Manthou, okay?
Okay, when is this? The 29th at 8:30?
8:30 in the morning.
30. All right, thank you.
Sure to work out for you, really. Thank you.
Thank you.
Thanks a lot. All right, Phelps versus Trenton Auto Parts. You guys both are here. This is going to be contested. I'm sorry. Let me go on to another case, okay? If it's unless you guys have a resolution. Do you have a resolution? No. Did you two talk? No. Try. Why don't you guys go into a conference room, see if you can resolve it? Yes, well, it's a small, he'll set you up in there. Midland Credit versus Diane Taylor, 2404276.
Good morning, Your Honor. Violet Osk on behalf of plaintiff Midland Credit Management.
Where's Diane Taylor? Is she here?
Your Honor, unless she's in the courtroom, she did not appear on Zoom.
Is Diane, excuse me, is Diane Taylor out here? I'm telling you, John, I gotta figure out a better way to do these. The papers all over the place here. All right, Midland Credit. Oof. This is done. Yeah, I should have a motion to set aside dismissal here. Can you hand it to me? What's that? Just a motion to reinstate the case?
And entry of default judgment, Your Honor.
And I'm not going to do that. I'll reinstate the case. Plaintiff's motion to reinstate granted. Plaintiff to serve by first-class mail copy of order setting aside dismissal together with copy of summons and complaint by first-class mail to defendant's last known address. So I want you to put all that in the order. Defendant shall have 21 days to answer complaint from date of service. I'm going to give him 28 days. 28 days to answer complaint. And then if there's no answer, you can submit your default judgment, okay? Anything else?
No, that is all.
Okay, submit your order. Thank you very much.
Thank you, Your Honor.
Thank you. All right, what else do I have here? Capital One versus Marcia Tong, 2501338.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of Capital One Bank.
Good morning. Where's Marcia Tong?
Good morning, Gary Apps, Your Honor, appearing on behalf of the defendant this morning for the purposes of notifying you it's been settled, I think.
Is that right, Mr. Sparta?
It is. We mailed out a consent order for signature on June 23rd. We just haven't received it back, so.
Mr. Epps, you're gonna get him back, get that back to him today?
I'm subbing. I'll notify them. They need to get to it promptly. I didn't know. I was simply told to let you know it had been settled. I didn't know the time frame for my client sending it in. I'll let them know it's got to be done stat.
Yeah, adjourned to July 29th at 8:30. I'll expect that nobody has to show up because I've got the proposed conditional dismissal or judgment, whatever you're submitting. Okay, so I'm just gonna adjourn the pretrial to July 29th at 8:30.
Sounds great.
Right.
Thank you.
Anything else? Do you have any other, Mr. Apps, do you have any other cases?
Not today with you, sir, but I do thank you for your patience, and I enjoy listening to your day. Now I know why I'm not a judge.
Mr. Barty, do you have anything else?
No, sir.
Thanks a lot. Have a good day. Mr. Katz, I saw your name on one and I can't remember which one it is. Can you enlighten me?
Yeah, good morning. This is ABC Auto Finance versus Brandon Lilly.
Okay, let me find it. Give me 1 second, please.
It should be in the 10 o'clocks.
Do you have the 10 o'clocks down there? How you been, Mr. Katz? I haven't seen you in a long time.
I've been well. How about yourself, Your Honor?
Doing pretty good. Just years are flying.
Yeah, I know that.
All right, ABC Auto Finance versus Brandon Michael Lively, 17B3702. Is Brandon Lively here?
I've not had him check in as of yet, Your Honor.
So he wanted to pay $100, $150 a month, and you filed objections?
Yes, Your Honor. This is, in this situation, he knew about this case back in 19. We were getting some money then, and I think it was an agreed order. And then the payment stopped, and we didn't hear from him until we just filed the most recent garn. He's making very good money. I mean, we're getting from the garnishment, we're getting $500, $600 per week average.
So you just want me to deny his motion for installment payments?
I'd ask that you deny it.
Did you ever do an order file a motion setting aside the installment payment order though?
Well, this is his motion today.
But he's asking to decrease them, right?
No, he's asking to, there's a pending garnishment right now. So he's asking to stop the garnishment so we can make payments.
I see.
And just another, we also discovered he recently purchased a house that's worth, I think, $300,000. He has $200,000 in equity in it. I just don't see a basis at this point for even asking for giving him an installment payment or without more information.
So you already got an order though, setting aside the initial installment payment order, which allowed you to garnish his wages, true?
Correct.
Good enough. I'm going to deny his motion. His motion is denied. Will you please motion to amend installment payment order? Denied. Will you please prepare me an order and send it over, Mr. Katz?
I will do that, Your Honor.
Thank you very much. Have a good day.
You too. Nice seeing you.
Good to see you. All right. Now what do I have? Okay, so I've got Phelps and Trenton Auto Parts. Do I have anything earlier than that? I haven't called yet. It's scheduled earlier than that.
Judge, that's the only one. There's another small claims that was at 9:30.
Michael Phelps versus Trenton Auto Parts. 2502198. Your name, sir?
Michael Phelps.
Trenton Auto Parts. Your name, sir?
Richard Jazerski, third.
I'm sorry. Give me 1 second. Can you please spell your name for me?
Last name?
Yes.
Jezierski. Third.
Okay, the third.
Yes, sir.
First name's Richard.
Correct.
All right, and this is You guys talked and didn't resolve it?
We talked in the hallway, we did come up with a resolution.
What is it?
I'm going to bring a used engine back to him, and he's gonna charge me 25%, and then I've got a credit card request to receive some money back. So I'm gonna have that fixed, and then he's gonna give me a refund, partial money.
You're going to return the engine.
Correct. Detroit and all parts.
Right. He's going to give you,
All the money back minus 25%.
so the claim is for 1101. So essentially, he's going to give you back, let's just call it, am I right that he's going to give you back $825?
That sounds about right, yeah.
That should be, I mean, we could make it 25 cents too. That's 75% or 25% of, is that what it is?
Yes.
I think we should prepare a judgment. Give me a judgment, please. Or is
Judge,
there?
I thought I sent those down this morning with the docket.
Do you have
John,
any?
I do.
Oh, that could be it. Yeah. Okay. You don't have the check now, do you?
What is it?
You're gonna give him a check, right?
So I tried working it out with them. There's a restock fee on the engine. That's what we're talking about now is I'm charging the restock fee, but I want him to remove, you get a chargeback on his credit card for partial payment. So I told him once the chargeback is removed from my account, at that point I would refund him on the engine. He would not receive anything today, obviously, until I get the motor back. So he's got the engine still in his place. I'll get to receive that.
Now, are you waiving court costs?
That's fine, I can wait for us.
I'm gonna fill something out for you. I just want to make sure that I'm incorporating everything, so I'm gonna read this to you after I'm done writing it out, okay? I'm gonna let the two of you take a look at this. There's a place for you to approve this on the second page and date it. For whatever reason, they have defendant's signature on the top. You're the principal of Trenton Auto Parts, right?
Yes, sir.
Okay, so you two go out in the hall or conference room, take a look, make sure this meets with your approval. If it does, sign the back of it, date the back of it where it says you're the defendant, obviously, and I'd like you to sign president or whatever your title is because it's a corporation, right?
It's a DBA.
Okay, well then you sign your name doing business as, okay?
Yep.
And then you would sign your regular name before anything else, before you leave, come on back in and we'll put it on record, okay?
Thank you, Your Honor.
Thank you, gentlemen. All right. Do I have Delaney Provencher versus Theron Parks. 2502156. You know what, folks? I'm sorry. I need to take 5 minutes. I will call your case first when I come out. Just give me 5 minutes. I'll be back out here. So just stay seated.
Damage.
2978, and then, okay, counsel, your appearance?
Good morning, Your Honor. Andrew Cates, P78212 for Synchrony Bank.
Is Jocelyn Rose Dewey out there?
I have not heard from Ms. Uwe, nor have I heard from Mr. Brammer.
No, Your Honor, I don't have either.
How long you been practicing?
About
How long you been practicing?
about 11 years now, sir.
If there's one thing that's changed in the 40 years I've been a lawyer is the number of lawyers that don't show up. I don't get it. And then judges are the bad guys when they enter a judgment. How can you miss this? They don't even have to get off their couch. I mean, they could be sitting in their patio doing these, and I still can't get them to show up. What do you want to do?
Your Honor, at this point, I would request a default.
Go ahead.
There were damages in this case of, I apologize. I was actually filling out my judgment as we were sitting. $5,581.57. And we are requesting court costs, which I was hoping to get a hold of the court file to see the service fees.
I have $20 in a motion fee. I have $75 in a filing fee. Let me see here if I have the proof of service. Do you have any indication what the what the service fee was, Jen? I don't have it here. You might have had 2 motion fees. It looks like you had 2 motion fees, $40. And you don't know what it is?
I don't have the proof of service with me, Your Honor. I apologize that I did not send that. I could waive the proof of service fee.
So you got 115 plus 5581 for a total of 56, 96, 57, right?
Plus the $75 statutory
Right,
attorney fee.
right.
So
Thank
that would
you.
be,
So 57, 71, 57, right?
Yes, Your Honor.
Those nuns pounded the figures, multiplication tables and division and adding and everything else into our brains. You're all set. Submit your judgment. Defendant failed to appear. Thank you very much.
Thank you, Your Honor.
What case do you have there, sir? What case do you have? What's your name?
Deontay Jones.
It's the Edward Rose and Associates, Judge.
Okay. Edward Rose and Associates versus the Landings Apartment.
Yes, sir.
And the Landings Apartments versus Michaela Manitak and Deontay Jones. 2403372. Okay. Now. Did you guys resolve this, counsel?
I haven't had an opportunity to speak with her. I'm happy to go outside and chat with her. As far as I know, there's a judgment against Deontay still. The order to set aside is only as to Michaela.
Why don't you two go out and see if you can't resolve this? Will you do that for me, please?
I will.
Thank you. Yes. Delaney Preventure versus Theron Parks. Counselor, which one do you have?
Your Honor,
Yeah.
me?
Yeah.
Oh, yes. It's S&D Investors, Your Honor, versus Ladrell Gardner, case number 2501355GC.
Okay, this one shouldn't be long. I'll come to you next, okay? Delaney Preventure doing business as Double D Construction LLC versus Theron Parks. Your name?
I'm Delaney Prevention.
Your name?
Karen Parks.
All right, and who is this?
Karen Montgomery.
I'm sorry, what's your name?
Karen Montgomery.
Say that again?
Karen Montgomery.
Theron Montgomery. All right, now listen. You two, you need to keep your voice up, okay, for me, everybody, please? By proceeding in the small claims division, you're giving up certain rights. Each of you are giving up the right to appeal my decision. Each of you are giving up the right to hire a lawyer, to demand a trial by jury, and to the extent that you may be entitled to it, you're giving up the right to seek in excess of $7,000. Do you understand that, Ms. Preventure?
Yes, I do.
Do you understand that, Ms. Parks? You don't have to give up those rights. If you do choose to, you can have the case removed to the general civil division, in which case you can appeal my decision. You can hire a lawyer, demand a trial by jury, and to the extent that you're entitled to it, plaintiff, you can seek in excess of $7,000. Do you understand what I just said, Ms. Preventure?
Yes, I do.
Ms. Parks? Do you wish to give up those rights and proceed here, Ms. Preventure?
Yes, I do.
Ms. Parks? All right, I'm going to ask all of you, including Ms. Montgomery, to raise your right hands. Do you solemnly swear or affirm? Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give of these proceedings will be the whole truth? So help you God. Ms. Preventure?
Yes, Your Honor.
Ms. Parks? Ms. Montgomery? Okay, nice and loud. You got to keep your voice up for me, okay? You're soft-spoken. All right. Defendant contracted at my company build a shed. She purchased for $1,000 plus the cost of fees and permits, which cost an additional $275. Defendant had hired a side contractor to pour concrete for the shed, which did not pass inspection, so I had to pay an additional $535 for the new concrete plus 400 additional labor to do the cleaning up and grading from the concrete being tore out and re-poured. Is all of that true? Did you hire a contractor to pour concrete for the shed, and did it not pass inspection? True or false?
I did hire a contractor, yes. That was
Nice and loud, nice and loud.
I did hire a contractor that the plaintiff recommended.
Is that true?
We were asked if we knew if there was a concrete person, and that's the person that we gave her. She was free to go anywhere she wanted.
So the guy you recommended didn't do it right. Right?
The gentleman that we told her about did not do it right, but she was free to.
I know, I get it.
Okay.
Have you used him before?
No, he was someone that was used on other jobs that we had been on. So it was just a construction thing.
All right, you go ahead and tell me what you got to say, Ms. Parks.
Okay.
Nice and loud. You got to go a lot louder.
His name is Danny, I can't remember his last name.
Danny Palmer.
Danny Palmer.
Okay.
He recommended, because I asked him for a recommendation, if he knew anyone. He gave me a guy named Mark, I don't know his last name. So he did the job, but apparently he didn't do the permits or something correctly. So he had to come back and redo it. To my understanding, Mark redid it because I was at work.
Danny Palmer?
Yes.
And then tell me that again. You kind of lost me. Danny Palmer, you hired to do the work, right?
I hired him for the shed. He's a carpenter.
Okay.
And he recommended Mark, who has a company who does cement work. So Mark did the cement. He didn't get, I guess, the approval or whatever he was supposed to do, which was included in my estimate in the contract with him from me to Mark.
Mark what? What's his last name?
Your Honor, Danny Palmer works with me in Belton.
So I had the contract with Mark and it included the fees and Danny knew that. And I even have paper, I even printed out the text messages where Danny acknowledges, oh, well, I'll have to get these fees back from him because he knew they were included in the fees and everything for the permits were included in my contract with Mark. And we had already agreed.
So somebody who worked for you recommended this Mark gentleman.
Danny Palmer
Right.
told her that.
Mark.
This Mark, I don't even know Mark's last name, but he told her that Mark did concrete and got them in touch.
Okay.
And they took everything from there. I had nothing to do with the concrete until the inspection was denied because it was put too close, because it was put too close to the easement line. And so.
What city was this in?
Brownstown Township.
All right. So the inspection was denied, then what?
So it had, the inspector told me that
It had to be redone.
it had to be redone. And so that's what Danny told Ms. Parks. And so, it had to be redone, but the guy's like, I'm not doing it. We had nothing to do with the contract.
Wait a minute, slow down. They said it had to be redone. Mark didn't want to redo it.
Mark didn't want to redo it. But, Danny told him, it's like, we've got to take care of this lady, okay?
Okay.
So, it ended up that the concrete had to be torn out. Once again.
Who did that work?
Mark came out and redid it,
Mark came out and took out the concrete.
took out the concrete.
And he poured the
but I-
cement?
But I had to pay for the concrete,
Okay,
okay?
okay.
I had to pay for the concrete, I had to pay for getting the permit for the concrete because there was no permit pulled. And so I paid for the permit for the concrete, I paid for the concrete, I paid for cleanup. I paid other people.
Who did the concrete?
Mark did the concrete.
So Mark, who had referred, I see. So you still got Mark to come out and do it.
Yes, but I had to pay for the concrete because he said she hadn't paid him the first time.
Did you pay him?
Every penny. Yes, it was a $3,000 contract and I paid him the $3,000. And Danny I even printed out all of the text messages from Danny, and one of them states Mark would have to pay for the cement part and the permit and everything because he knew that I had already paid for everything. I took care of everything until the city sent me a notice saying that I'm gonna be fined $100 a day because they didn't do it far enough off the easement. So they had to come back out, he had to come back out with his, it's called Mr. Crete, and all I had was Mark.
So you paid Mark $3,000.
Yes. And.
Hang on.
Oh, I'm sorry.
And you paid Mark again?
No, I didn't pay Mark, I just paid for the concrete for the second floor.
Well, you also paid for permit fees,
I also
right?
paid for the permit fee.
How much did you pay Mark?
I didn't pay Mark anything. I just paid for the concrete.
Well, I know, but how did you pay for the concrete? Did you pay
I
through your
paid-
company
I
or did you give it to Mark?
I paid for the concrete through my charge card.
Okay, how much was that?
It was $535 from Wallace Concrete.
And then you paid, hang on, and you paid the permit fees of how much?
I paid $75 for the permit for the concrete.
All right, so you had essentially out of pocket with regard to the concrete, you had $610. Is that true or false?
I'm gonna say yes because I don't have a calculator on top.
Well, 525, well, you had didn't you say
525 and 75.
I thought you said 535.
And 75.
That's 610.
Yes,
So you paid 610 out of pocket.
yes, sir.
Why should she have to pay that? She already paid the guy.
Okay. The thing of it is like,
And do you have any reason to dispute that she paid this guy?
me?
I'm asking you if you have any reason to dispute that she, the defendant, paid this guy.
Anything I can say would only be hearsay, Your Honor.
Well,
I don't know that she paid him. I don't know that she didn't pay him.
okay.
All I know
Do you
is
want to go
what
call him up and find out if she paid him?
I don't even have a phone number for him.
Did he never told you that she paid him?
He told Dan Palmer that she didn't pay him.
He told Dan Palmer that she didn't
And
pay him.
Dan Palmer was here, but he had to leave to go to go work on a job.
Do you want to go have Dan Palmer log on to Zoom?
He had, oh, Your Honor, there's no technical gene in Dan Palmer, so no.
Okay.
He would not have any way of knowing how to do so.
And you're promising me, you're under oath.
I am under oath.
No, I'm looking at her now. I'm looking at her.
Oh, okay.
Okay. You're promising me, you're assuring me, Ms. Parks, that you paid Danny Palmer $3,000.
I paid.
Mark, I misspoke. Mark, $3,000, right?
Yes.
What are you looking for on your phone?
I'm trying to look and see if I have a check under my account, under my, in my, electronic payment thing. And see if I can just.
How much was the contract between you and Ms. Parks, Ms. Provencher?
We were going to charge $1,000 for for putting up the
Shed.
that she had purchased.
Did she
Plus-
pay you?
No, plus the additional fees of $250
For what?
for the permits and fees that were required for Brownstown.
For the concrete?
No, not for the concrete.
For the shed?
Alone, yes.
Okay. You agree that you at least owe her that, right?
I did, and I had a check for him the day he came for it. And I had also told him since January, I've been telling him, I need my receipt for the jobs he had done. And
Who you talking about? Who's he? Okay.
he had broken a door, which I have a picture of. And I said, I still need that door fixed that you broke when you were installing it. He kept saying that he didn't have the receipt, he was in his car, in his truck, then he said his wife had it. It was always since January, I can't get that receipt. I said, okay, please bring the receipt, every time I talk to him, please bring receipts, please get me the door. Then I said, okay, make sure when you come to get the check, don't forget to bring the receipt for the door and the receipt for what I'm about to pay you now. He came there completely empty-handed, and I asked him, I said, well, where's the door and my receipts?
The door to the shed you're talking about?
No, the door for another job, but the receipt for this job.
This was something else. I'm only here for the shed.
So the receipt for this job, he refused to give me a receipt saying that I'm paying him and the door that he broke before. And I'm like,
what door?
All I want is the receipt.
Your Honor, he had done other work for her that was not part of this.
Okay, so that's between you and him, right?
Yes, but even the receipt for this job, I'm like,
I know,
just give me the
but
receipt.
you agree that you owe her at least $1,250, right?
No, it was $11.75 because $75 the city of Brownstown said was for the concrete permit. I already paid for that through my
But I had
contract. That's not my fault. I paid for that through my
Yeah, but
contract.
this guy didn't work for her. The cement contractor did not work for her,
Yes,
right?
but she's saying she repaid for a cement receipt that I already paid the cement contractor to pay for.
There was never a permit pulled on the concrete at all. If there had been, then the inspector would not have allowed them to set it back as far as they set it. It was too close to an easement.
Yeah.
I've got a copy of the plot.
How do you get to $2,210 on
That
this?
includes the concrete, what I had to pay to do the grading and stuff after the.
Did she ever convey to you, Ms. Parks, ever convey to you that she'd already paid this gentleman the $3,000?
No, I never knew that.
Danny, I never spoke to this is the first time I've ever seen her, ever. Danny.
But Danny worked for you, right?
Danny works with me.
Did Danny come back and tell you $3,000?
No, Danny came back and said that she hadn't paid Mark anything. This was back in January when they weren't even supposed to report anything.
And you assure me you paid $3,000?
Yes, yes, I definitely.
Now, he's your employee, though.
Who, Mark?
Yeah.
No, Mark is nothing.
Wait a minute, slow down. I'm sorry, I'm getting confused between the Mark and Danny. Mark,
Is nothing to me.
I know, Danny is your employee. And
Danny
she
works
assured
with me.
Danny that she paid, she's saying she paid $3,000. She says she told Danny. Did you not tell me that?
I told Danny, yes, that I had paid him.
And did Danny ever convey that to you? He worked for you.
No, he did not because I wasn't part of the concrete. He was just trying to work with her in getting her concrete done so that we could do the shed. That's the only thing we had to do with the concrete until I had to pay to report the concrete. And I had to get a permit to do it because there had never been.
You guys should have brought in this guy.
Her problem.
If Mark got his money, if Mark got his $3,000 and then you're paying for it, it sounds like he didn't lose anything other than the fact, I guess, he had to pour the concrete
He lost
second.
his reputation as far as I'm concerned, but no, as far as monetarily, he didn't lose anything. Your Honor, I would be perfectly happy if I could just collect for the shed and the permits that I paid for.
And that's $1,250, right?
I have also received the text message that Danny even agreed that minus the $75, because I wrote it for $11.75, the check. Because, that would be.
I don't know why she isn't entitled to that.
And then the shed is already falling apart. When we had that wind, it blew off.
That's not our problem, sir. She bought the shed from Amazon.
You didn't put it together.
It was put
properly.
together per instructions.
That's not before me here.
But I have a copy of the letter that, from back in December, from the, building department to Ms. Parks about the, cement pad being in the backyard, being not in the right place and everything else. So she was aware of it and she could have, she could have done anything she wanted to with Mark.
I told Mark, I told Danny that I was going to sue. Danny convinced me not to sue. He says, let me try and handle it, and I have that in the text. Let me try and handle it, we talk to Mark and see if we can come with some resolution. I never asked him to go and pay for things that I'd already paid for.
Like I said, Your Honor, I would be perfectly happy.
I know, and I think that's fair. Judgment is for plaintiff, $1,250. You also paid a filing fee of $88. Did you have any other out of pocket?
No, sir.
$1,338 is the total. You gotta remember something, she really didn't have anything to do with that. She didn't hire the contractor, you did.
Yes.
I'm just telling you, this is fair. Can you pay her now?
I can pay, but I still don't get a receipt for it. I don't get the receipt.
Hang on, slow down. Slow down. Everybody slow down. Ma'am.
You're saying wait for me to finish.
If you pay her the check, that's a receipt. What do you need a receipt for?
Because
Do you have a check right now?
I can write the check.
Can you write her a receipt right now? Can you write her a receipt?
I'll write it right on this kind of.
Yeah, you guys, come on now. Let's not act like 9-year-olds here. You guys can figure that out. You're gonna pay by check. She's gonna write you a receipt. I'm entering a judgment. You can go down the hall and take care of that. If there's any problem, you two come back here, okay?
Could you give me that number again, please?
$1,338, because I'm charging filing fee she's entitled to her filing fee. So it's $12.50 plus the 80. Okay? Thank you all.
Thank you, Your Honor.
All right, S&D versus Ladero Garner, 2501355.
Ready, Your Honor. Daniel Goldman, 64231 for the plaintiff.
All right, is he here, Ladero Gardner?
I've not had him check in, Your Honor.
Counsel, I'll give you a default if you want.
I do, Your Honor. The amount of, I think we had a proposed judgment with our motion, Your Honor. Judgment for $2,810.72.
Well, so you filed a motion to strike his answer, right?
For a more definite, yeah, motion to strike or for a default, or in the alternative for a more definite statement. He gave us, Your Honor, a letter answer.
Yeah, I don't think I can really give you a judgment. He didn't show up on this. I can give you an order requiring a more definite answer if you want. Let me see here.
Well, Your Honor, we think, as our motion states, for what it's worth, that the answer was a failure to answer, and therefore it's deemed admitted. We have a detailed complaint. He certainly has personal knowledge about whether he had these accounts or not. Instead, he gave us a letter answer, which I think he just Googled how to defend a credit claim and sent that to us. But it's very clear what the charges are. The complaint is detailed. He didn't answer. In the alternative, we've asked for a more definite statement within 7 days, or in the failure to do that, I would ask for default.
All right, yeah, I don't feel comfortable giving you a default. I'll give you an order requiring an amended answer. I'm gonna give him 21 days. And if he doesn't, then you can file your motion again and I'll grant your default, okay?
Thank you, Your Honor.
All right, thanks a lot. Have a good day. Sorry to keep you waiting.
Thank you, Your Honor.
Within 21 days, Jen.
Yes, Judge.
All right, now, JP Morgan versus Jokela. Did I call that one already?
No, Your Honor.
Danielle R. Jokela, JP Morgan Chase versus Danielle R. Jokela, 2403002. Anybody here on this one? Where's Danielle Jokela? Is she here?
No, Your Honor. It looks like there's no attorneys that have appeared. I will see if anything's been filed. Hold on one
Was
moment.
Mr. Royce here? Or did I hold a pretrial? Did I do this one?
It was set for bench trial today, Your Honor.
Okay, wait a second now. Sir, you're gonna have to control the child. I'm sorry, but you're gonna have to control the child, please.
Sorry.
Did I not call this one?
No,
You did not, Your Honor, but it was set for bench trial today at 10, and it does not look like either party's appeared. We're checking to make sure nothing got filed at the last minute.
Was Mr. Royce not in here today? I thought he was in here on something.
They were here for JP Morgan Chase and Susan Swaffer at 8:30.
This is. I don't know what to say anymore. You're sure I didn't call this case, right? Nobody showed for trial. It was scheduled for 10, right, Jen?
That's correct, Your Honor.
Case dismissed. All right, now, St. Louis. Ronald St. Louis. Oh, wait a minute. Let me get you guys out of here. Michael Phelps versus Trenton Auto Parts. Your name?
Michael Phelps.
Your name?
Richard Jazarski.
Can you hand that up? Did you guys sign it?
Yep.
Any problem with it?
No.
Hand it up, I'll sign it, you'll go down the hall and you'll get a copy of the judgment.
One thing is though, just on, if we could, refund won't be processed until he contacts his credit card company removing the chargeback.
How do you want me to word it? Refund?
Refund will be processed.
Hang on, slow down. Will be processed.
After chargeback is removed.
You agree to that, Mr. Phelps?
I do, Your Honor.
I'll add that. I did forget to put that in. My apologies. I'm gonna go ahead and sign the order. Everybody's satisfied with this, right?
Yes, Your Honor.
Yes, sir.
And you are? How many gold medals did you win again?
None, I would have.
Good luck. I know. I mean, I know. You gotta have a silly sense of humor sometimes. Ronald St. Louis versus Brian Marshall. Have a good day, guys.
Your Honor,
Hang on.
if I may, back on the JP Morgan Chase and Jokella, Linda just looked at 8:30 this morning. They e-filed a stipulated dismissal, but
I'm not gonna
a stipulated order.
Make sure you change that on the paperwork. Come on
I
up here.
will.
St. Louis versus Marshall.
Your Honor, Mr. Scanlon at 10:13 this morning filed an appearance and a demand and order for removal. He is on Zoom, but he's indicating he's on another court at the moment.
He's appearing for who?
For me, Your Honor.
Wait a minute. Turn that podium toward me, will you please? Toward me.
Turn it the other way.
What's your name, sir?
Ronald St. Louis.
And your name?
Brian Marshall.
Where's the demand for removal?
It was just e-filed at 10:13 this morning, so it's in your box, but you don't physically have it.
All right, guys. I didn't know, or I wouldn't have made you stay here. What's your name, sir?
Carlos Velasquez.
They have the right to have the case removed to the General Civil Division, Mr. St. Louis, and that's what they've done. So he's got a lawyer now, and you can hire a lawyer if you want. I'm just telling you can. They have the right to do it. This isn't my rule. I don't make rules. They have the right to do it. So you can if you want. I'm just telling you, now that it's not going to be in the small claims division, the proceeding becomes much more formal. You can hire a lawyer, you can demand a trial by jury, you could seek in excess of $7,000. If you think you can prove that you're entitled to it, and you can appeal my decision. Do you understand that?
I do.
So all I'm gonna do is sign the demand for removal. We'll set it for a pretrial. We'll give his lawyer notice. You can hire one if you want.
So, on the tools that he's stolen from me and he's keeping, I can now go after him, which I didn't want to do. He's my stepson, and my ex-wife was his mother. It was explaining what was going on between him and his girlfriend. Criminal charges for theft.
Well, you do what you gotta, hang on.
Do I have the
Hang
right
on.
to do that?
You can do whatever you want. Go talk to the police if you think there's a theft here. Absolutely, but I'm not sending you over there saying to go fight.
No, if I have the right to do that. That's all.
If there's a theft, you always have the right to file a criminal complaint.
Yep.
Okay?
Yep.
And we'll send this out. We'll give you a pretrial order, all right?
You got it. Thank you very much.
All right, good luck. All right, who's here on Edward Rose in Menatac and Jones? This is 2403372GC.
Attorney Lee Melvin, Your Honor, P8373, appearing on behalf of the plaintiff.
Do I have the register of actions? Yes, I do. All right, wow, this has been going on a while.
Right to the podium.
So your name, man. Sir, your name.
Deontay Jones.
All right, counsel. What have we got here?
So this is scheduled for a bench trial, Your Honor.
I see that.
We did go in the hallway and talk. We didn't come to a resolution today. There was some new information that I hadn't received from the defendants. What we would ask today, and I think we both agree, is to adjourn and they can provide information to me I don't have.
I can't adjourn this very long. This case is old.
I think this case was filed.
September.
Right, but we didn't get service until.
I'll adjourn it 1 month for trial, if that's what you guys want.
Yes, that's fine with us.
But I would ask that, you know, any documents that they have be turned over to the plaintiff. Because.
I don't know anything about this case. It's for 144670. Is that the only thing this is up for today, is trial?
Yes.
Yes.
Did you not say, or somebody say, that Deontay Jones had a default judgment entered
Yes.
against him?
There is a default judgment against Mr. Jones. We made a default request against this men attack. The court ordered that be set aside.
Okay, so I gotta have my cases done within a year. I'm just telling everybody, all right? And I don't, these are not my rules. It's the Supreme Court, and that's what they tell me, or else I gotta go and report. I'm gonna adjourn this 1 month. Is everybody gonna be ready for trial then?
Yes.
Yes, I mean, the main reason that I would like to adjourn is she provide confirmation of payments that I don't have.
Okay, good enough. Give me a date like August the 20th or something, Jen.
26th at 10:30?
At 10:30, no more adjournments, okay, folks?
Yes, sir.
All right, that's it, August 26th at 10:30. I wish you both well. Thank you very much.
Thank you.
Have a wonderful day.
Thank you for your time, Your Honor.
Thank you very much. Okay, John, I'm sending down some Zarowski's advice or rights here.
I'll get them all matched up.
I think I've got everything down here. And I think that's it. Am I done?
Yes.
Yeah.
Right? All right, thank you.
Your Honor's gonna send out a notice to appear, correct?
Was that?
A notice.
To talk, speak.
And
Do they know you're doing that?
Yeah, and public record.
Kind of going down a timeline like they did.
Don't speak to anyone else. I've already talked with my assistant this morning. He said that he has not heard me.
Good afternoon, everyone. This is Judge Middleton. I'm at the courthouse in Centerville. Miss Arnsby, if I can get you to unmute.
I'm here. Good afternoon.
All right, good afternoon. Miss Winchell, can you hear me?
Yes.
We're a little early, but let's just get right to it. You're each here on a small claims matter. Miss Winchell is suing for $600. She has sued Brandy Lynn Arnsby and Tristan Arnsby, but we don't have service on Tristan Arnsby. So this matter is just regarding Brandy Lynn. It's a claim for $600. You are in small claims court. In small claims court, the rules are different. They're more relaxed than the general division of the district court. Neither party is allowed to have an attorney. There's no formal record being made of a small claims proceeding. There is no appeal from a small claims proceeding. Any decision made here is final, and there is no appeal. Either party has the right to remove the matter from the small claims division to the general division of the court you have to still tell me before we begin. Once we begin here, Ms. Winchell, any decision is final. Do you understand?
Yes.
Ms. Arnsby, you understand as well? All right, well, let's put you both under oath. Are you Tristan Arnsby?
Yes, I am.
All right, why don't you raise your right hand too? All right, you all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
All right, I read the pleadings and I looked at the telephone text messages. Ms. Winchell claims that there was some sort of agreement with the Arnsbys to give a lawnmower in exchange for mowing this property on Clark Street in Mendon. And the mower was never transferred, so she is sued for damages of $500 plus court costs. Miss Winchell, why do you believe that they owe you $500?
Well, their property, we had to come to an agreement with to mow. It was very tall in length, their grass. It was on 5'2", and it was past my knee at the first cut. That first cut took us 4 to 5 hours in multiple passes.
Well, let me ask this. Why were you responsible for mowing this?
My boyfriend and I were mowing the property because Brandolyn and I came into an agreement for me to take care of this property by lawn mowing for an exchange for a mower or cash.
All right, that's where this case has problems. We have to find there's some sort of an agreement. I'm not sure we got there yet. What kind of lawnmower are we talking about?
It was a Cub Cadet riding lawnmower.
And how did you and Miss Arnsby come to know each other? You were the real estate agent that brokered the sale of this house?
I'm also her cousin.
Okay. Did you broker the sale of the house?
I was helping them with buying the house as their agent.
All right, so you were the buyer's agent?
Correct.
Just in Mendon yesterday. I understand this house was in bad shape and had to be gutted or emptied before anybody could do anything. Is that true?
Yes.
All right, in your text, you're in a yank to get over there and mow this place. But they're like, we're not ready yet. We haven't got everything out of there and there's still junk in the yard. And I didn't get all the way back to somehow you said there was an agreement between you and Brandolyn to mow this. Tell me when and how that happened.
Great. So our agreement was actually through a phone call through Facebook Messenger back, I believe, at the beginning of July, if not at the end of June. Once they were to get possession of the property, that's when the lawn taking care process was supposed to begin. But that was over a phone call, and I don't have records of that phone call.
Well, in your pleadings, and then often we struggle right off the bat. Brandolyn and I entered a verbal agreement of services in exchange for a particular item or cash. So when we're talking about a verbal agreement, it often becomes he said, she said. The service was for lawn care, work on flipping their new house in Mendon in exchange for a lawnmower or services given. So was this lawnmower purchased with the house?
No.
All right, you guys brought a Cub Cadet mower over there?
My mom was giving me the lawnmower. At the time that we purchased it, I was living in Washington State, so I had not been to the property yet. There was no verbal agreement that I would ever give her my lawnmower. She asked me if she would be able to borrow the lawnmower because her husband, or her boyfriend, sorry, was starting a lawn care business and he really liked that lawnmower and they needed more lawnmowers. I told her as a family member that, yeah, sure, she could borrow my lawnmower if they needed it. I came to find out later that they had 5 lawnmowers already and didn't need it. They kept asking me if they could mow the lawn, and I kept saying, we don't need our lawn mowed. We had a house that was unlivable. We're in the phase of just like taking all of the insides out and throwing everything from our house into the yard at that point because we had a full renovation to do. So we didn't need our lawn mowed, and we had a lawnmower.
So you brought this property sight unseen from Washington?
Yes, Your Honor.
I'm trying to picture which house it is. I guess I could have looked it up. I probably drove past it yesterday. How did you come to buy this?
We found it on Zillow. My family is originally from Bronson, and so we were looking to move back and purchase property. My husband, Tristan, does construction, so we took it on ourselves and remodeled the whole thing.
All right, when did you move back?
Beginning of August.
Of 24?
Yes, Your Honor.
All right, when did you purchase it?
It was June or July when we actually purchased it. Leanne, do you know the day? About mid to late July.
All right, and then you moved back here in August?
Yes.
In the exchange of text messages, I don't see any agreement for this. Good morning, Muffin. I was wondering if you could leave the key for your house this weekend so Mark and I can go inside if we need to when we mow tomorrow. So something precedes that. That's August 2nd. So who is Muffin? Brandon Lynn?
That's me. Yeah, we did. So when we purchased the property from Leanne, it was her first house that she was selling, and it was the first house that I was buying. So we went on that journey together. And during one of our phone calls during the purchase agreement phase of buying the house, she said in her own words that her boyfriend has OCD and really wanted to mow the lawn because he'd been out on the property with her during that process, I guess. I'd not been here, and asked if they'd be able to mow it, and I did allow them to mow it the one time. The second 2 times, I did not give consent for them to mow my lawn.
Okay.
And I also
All right, I don't think we're ready to mow yet. We haven't cleaned out the yard for you. We almost finished throwing all the trash into the house. We'll have a dumpster by next week. I do have a favor. What a shit out there. Almost everything out. Then we're into August 10th. So, all right, there's another theory under the law in quantum merit where they did work and they ought to be able to be reimbursed for it.
So, Your Honor, if I may.
Yes.
Come to our house one day because they asked if they could help us with the house. We said, sure, you can come over and help us with it. When we got to the property, Leanne and Mark were both mowing on without asking. And we said, that's not what we asked for. And they said, well, we're almost done and then we'll help you. And then they helped us for a couple hours at the house. We took lunch, we paid for their lunch, said, thanks for coming to help. Everything was at that point.
Well, you make it sound like you're doing a big favor. Hey, we allowed them to mow our lawn. The village of Mendon probably doesn't like having knee-high grass on this house right in the middle of town on Clark Street with junk all over in it. And so maybe he is OCD and could stand to see it like this. But you're like, we allowed him to mow it one time, like somehow that was generous of you. She said it probably took 4 or 5 hours to cut it. So the first time you say you allowed them to mow it, then the second time they were mowing it and then you got there. They were mowing it with that Cub Cadet mower.
No, they had brought some push mowers over from, I guess, their house. I'm not sure. We never discussed them mowing our yard at that point.
All right. So do you think they deserve nothing for all that?
I mean, I don't think that it would be fair for me to say I should pay you money for something that they asked us if they could do that first time. There was no compensation ever talked about. So that I feel a little bit like I don't totally understand the law, but it kind of seems to me like then anybody could just go mow anybody's house and then send them a bill in the mail months later because they got mad at them and then take them to court and then ask for money. I don't see how that.
All right, well, that is true, but you aren't just anybody. You're related. You had a relationship. You exchanged texts about it. There was no meeting of the minds. There was no contract with offer, acceptance, and consideration. However, there's a bunch of hard work twice. And it's like, well, sorry, you offered to do it. Too bad. Then they get mad. She thought there was some deal for exchange of the mower. You, on the other hand, had no clue that there was a discussion about giving them the mower. So she had one mindset, you had another. So you didn't have an agreement on what the deal was. But there's this other theory called quantum merit, that if you do something, you should be able to be compensated for it. She already gets her court costs. I'm going to split this in half. I'm going to order half of $500, which is $250 and $66.25 in cost.
Okay.
You guys probably aren't going to have Thanksgiving dinner together. It's too bad it came to this. You owe $316.25. And as I indicated, the Village of Mendon probably didn't like this. So the house has been refurbished now?
It's still in the process. It's almost done. The first floor is done. We're still working on the upstairs. So yeah.
Is this the great big brown one?
No, it's a little white one. There actually were the people who owned the property before us were drug users in the town that had warrants out for their arrest. The police were involved in the whole matter. And then they were squatting on the property after we purchased. So the town actually was okay with the mess for a while because they were just.
One mess is lesser than another mess.
Yeah.
All right, that's my finding. You know, $250. I cut the claim in half. $66.25 in court costs. The damages are only to Brandon Lynn. There was never any service on Tristan Arnsby, but he's in the same position. You did not have a meeting of the minds. You did not have a contract. Work was done with your consent without a meeting of the minds, but work was done, and that's the quantum merit theory. So I'll send you a copy of this judgment. You just send her a check within 30 days, the matter will be completed. All right, you're both good to go. Thank you.
Thank you. Thank you.
I want to apologize for the wait we had there, Mr. Martin. Did you have a chance, Mr. Martin, to watch that video?
I've seen the videos that, of the cops going in my house.
Okay. So
But there's still, but not the video of the other court case my sister.
Well, I told you I'm not entertaining video from another court case.
You can attack her credibility, but I don't know.
Okay.
Okay, well, anyways, yeah, on that, but there's something.
Okay, well, wait 1 second. Can I get your appearance, counsel?
Yes, Your Honor. Good afternoon. Natalia Asmer on behalf of the people, P88493.
Okay. And Mr. Martin?
I missed her, but I object to the mister. The mister understand what does understand, but
Okay. What's your first and last name?
it would mean that I'm not one of the sovereign people, and I am one of the sovereign.
Okay, well, you're also a citizen of the United States, and you have a birth name, and it's Eric Martin. I'm familiar with you all, except your appearance. All right, any other preliminary matters before we start testimony?
No, Your
Yes.
Honor.
All right, go ahead, Mr. Martin.
Yeah, some motions, but one of the things I need I need someone to testify for, and that's the tax assessor, Jessica here, that's next door, which supports my sister being a liar.
All right, that's not relevant.
Her not lying is not relevant, that doesn't make sense.
You can ask her questions about
No, I'm not
that.
talking my sister, I'm talking about the tax assessor will admit something, if she's questions which the quickest, easiest way would be like you call her, or I need to call her, subpoena her in the court to testify to something which will.
What, give me an offer of proof. What is she going to tell me?
She's gonna say the house's name, I mean, the 9074 Clifford Street where we live at, that house is in my father's name, which this is what Jessica told me. This would support my sister's lie, how she keeps on saying, it's my house, it's my house. She's all in the video saying that 1,000 times.
Okay.
So that would attack that she's a liar, which would attack her lying allegations in this complaint that she's a liar, and therefore it's relevant for that.
Ma'am, can you stand and tell me your first and last name?
Lisa Martin.
Miss Martin, is the house in your father's name?
Yes.
Okay, that's it. That's all I need to know. All right, I'll take judicial notice of that.
Okay,
That
thank
the
you.
house is in your father's name. Anything else?
No, not as to that, no, actually, no, I have some motions now, yes, besides that.
All right, Mr. Martin.
And, okay, I move to dismiss based upon, my right to slavery, against slavery, that is, under the 13th Amendment. These proceedings from the jump have been proceeded against my consent. I never consented. If it's ever fraudulently assumed I consented, again, it's fraudulent. And it's not true, and therefore violates my right to slavery.
Okay, denied. Next. Mr. Martin, I'm going to start taking testimony soon. I've entertained about 10 motions to dismiss from you already this morning, so.
I have one more. No, that's about, I have one more. That's all I think of right now. I reserve my right to bring it up again if I think of it.
All right, at the end of the prosecutor's case, you can bring a motion if you have one, okay?
Okay.
All right, any other preliminary matters?
No, Your Honor, I did just want to place on the record that I did show all the digital evidence that we have in our possession to Mr. Martin.
Okay, he's indicated on the record that he watched those videos.
Yes.
So, okay, call your first witness.
Thank you, Your Honor. The people call Lisa Martin.
All right, Miss Martin, come on up to the witness stand here. Oh, stand. And Miss Martin, when you get up here, I need you to stand and face me, okay? Ma'am, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, if you can have a seat in the witness stand. Is Lisa Lisa?
Yes.
All right, you're a witness.
Thank you, Your Honor. Good afternoon, Miss Martin. I want to direct your attention back to the date of June 12, 2025. Do you remember that date?
Yes.
Okay, and on that date, were you at or near location 9074 Clifford?
Yes.
Is that in the city of Taylor, County of Wayne?
Yes.
And what's at that location?
My house.
Okay, and who lives at that location?
Well, it's my house. Both my brothers live there. I've
Who are
given
your
them an
brothers?
eviction notice.
Who are your brothers?
Eric Martin, and I have another younger brother, Kurt Martin. They both got served eviction notices. They're supposed to have been on October 17th, and they ain't out.
Okay, and Your Honor, the witness did point to Mr. Martin seated at the defense table with the, let the record reflect that the witness has identified Mr. Martin.
Do you have any objections to the identity of you?
Well, just the same objection from the jump that I'm not the defendant named in the complaint. It has a similar name to me.
Okay. All right, it's admitted. The record shall so reflect.
Thank you, Your Honor. Okay, and on that date, June 12, 2025. Did something happen that day that brings you into court?
Yes.
What happened that day that brings you into court?
I was sitting at the kitchen table on my phone. My brother came through the back door.
And when you say your brother, you mean Mr. Martin or?
Yes.
Mr. Eric Martin?
Yes.
Okay.
Came through the back door, walked past me, went over to my little radio that I listened to. There was a volume level from 0 to 10, it was on 2. Okay, just goes up to it, turns it down. He does this like 10 times a day. Went, turned it down, walked in his bedroom. I walked down the hall, stood at his door, and I said, you don't touch the radio. He goes, get out of my room. And he charges toward me and pushes me.
Where are you standing?
I'm standing right at the beginning of the bedroom.
Okay, like behind it, or are you in the bedroom?
No, I'm not in the bedroom. I'm standing right outside of it.
Okay, and Mr. Eric Martin is inside the bedroom and he charges at you?
Yes, yeah. He's at the furthest part of his bedroom, so about 7 feet away from me. And he said, get out of my room. And then he comes toward me and shoves me, and knocks me off balance. I didn't fall. And then he pushed me again, but his hand like hit my neck right here. It was like a karate chop, but he didn't like try to karate chop.
All right, next question. You got to let her ask a question. She'll ask you, and then what happened? And then what happened?
Thank you. So you stated that you were knocked off your balance. How were you knocked off your balance?
When he shoved me.
And you're making this motion, did you use both hands?
And the record shall reflect she's got both of her hands held up and pushing them away from her at shoulder height.
Thank you, Your Honor. Okay, and did you fall on the floor?
No.
Okay, and then you stated he tried to do that again?
Yeah, he tried to like push me again or something, but his hand like this, I don't know if it slipped, but it hit me like right here, and it hurt for a little bit, but I didn't, I was fine.
A record shall reflect the witness is pointing to her neck area.
Thank you, Your Honor.
And then that was that. And I told him, I said, you don't learn about putting your hands on me. That was the 16th time in 4.5 years that it's been my house that he's put his hands on me.
Did you allow that sort of touching, that being shoved and?
No,
All right, and just for the record, I'm not accepting the prior instances or allegations of prior instances, so that's stricken from the record.
Of course, Your Honor.
Go ahead.
Okay, and did you sustain any injuries at all?
Yes.
Okay, and what kind of injuries did you sustain?
A couple of days later, I noticed when I was getting dressed to go to the store that I had a bruise on my arm. So I took a picture of it, a couple of them, and then in a week or two later, it was still there, and I took pictures of that, yeah.
Okay.
And the bruise just went away 5 days ago, so it was there for 3 weeks.
And would you recognize those pictures if you saw them here today?
Yes, they're my pictures.
Okay. And Your Honor, may I approach the witness?
Yeah, are these proposed exhibits?
Yes, Your Honor.
What are they?
They are
1, 2, and 3?
Proposed 1 and 2.
Proposed 1 and 2. Okay, you can approach the witness.
Thank you.
Just show.
That's the first one.
I'd like to get a copy of those too.
You have a copy of those, Mr. Martin.
What, I'm not papers, what do you mean?
I thought those copy photos were.
I can show you 10 pages, I got it on.
I was provided with copies. I left them in that room because half of the picture was chopped off.
Okay, I'll get you a copy.
All right.
And then may I approach the
You
witness?
can approach.
Thank you. Starting with people's proposed exhibit number 1. Do you recognize what I'm showing you?
No, that's my arm.
Okay, and.
It looks like a foot, but it's my arm.
Okay, and do you recall what day this picture was taken?
Yes, there's dates on the pictures. It was taken on the 16th.
Okay, and does this photo appear to be manipulated, changed, or altered in any way?
I don't know how to do any of that.
Okay, and Your Honor, moving to admit people's proposed exhibit number 1.
All right, does that accurately reflect the way your arm looked on that day?
Yes.
Any objections, Mr. Martin?
Yes, I object to the pictures being admitted based on the prosecutor told me, as I asked her, when was they taken? Prosecutor admitted it was taken 4 to 7 days later from the alleged, this allegedly happened.
All right, she
And based on the
allegedly,
timeliness of it, I moved to dismiss it.
All
from
right.
that. This violates my due process right to fairness. To
Okay.
timely.
Mr. Martin, the witness just testified that photo was taken on June 16th, which would be 2 days after the alleged incident. So that's her testimony.
It should have been taken immediately. And the
Do-
prosecutor, the disputes like this, what the prosecutor told me, it was 4 days to 7 days later. she told me.
Okay, do you have any other objections to the photo being admitted?
Besides the timeliness, it's not a current, well, I mean, it's not true.
Okay, okay,
That's maybe
it's
my-
admitted. You can
For my
ask questions about the photos, but the photo's admitted.
Thank you, Your Honor. And for the record, the date of incident was the 12th of June and the photo was taken on the 16th, so it was 4 days after.
4 days after, okay.
Okay, and then do you recognize, I'm handing you it's marked as people's proposed exhibit number 2 as well. Do you recognize this photo?
Yes, that's my Bruce, still a week or two later, it's still looking like that.
Okay, do you recall the date of this photo?
I think it was 23rd,
Okay,
22nd and 23rd.
and did you take this photo?
Yes.
And does it at all appear to be manipulated, altered, or changed?
No,
Is that-
no, I took the photo.
And is that the same as how it looked on that day
Yeah.
it was taken? And Your Honor, the people are moving to admit people's proposed exhibit number 2 as well.
All right. Do you have the same objection to the admission of this photo, Mr. Martin?
Yes.
All right, it's noted for the record. They're admitted over objection. 1 and
you,
2
Your Honor.
are admitted.
And Your Honor, may I publish the photos to the court as well?
You may.
Thank you.
Okay. Ma'am, can you tell me where on your arm is that injury at? If you could just point to your arm, where is that?
It was right here.
All right, so in between the elbow and the shoulder.
Yeah,
On
it looks
the
like a
interior.
foot, because my arm fat's hanging, but that's exactly where it was. See how it hangs?
Okay,
It was right here.
all right.
And
Record should
you can see one
indicate,
of my spots in the picture too. That's where it was.
all right, record should
And it just
indicate.
went away.
Miss Martin, let me make the record here. Record should indicate that the photograph, the witness has indicated that that is her left arm in between her elbow and her shoulder blade on the lower portion of her arm.
Thank you, Your
Or
Honor.
interior portion of her arm, we'll say. Okay,
And then, Your Honor, this is people's exhibit number 2 from the 23rd.
okay, same area and location as the first
Right.
photo.
Yes, Your Honor.
It's still there.
And Ms. Martin, the photos that you were just shown, was that you stated that that was the left interior of your arm. Was that the same, was that the same area that you were shoved in earlier on that day on the 12th?
Yeah, when I was shoved, like I said, it takes a while for a bruise to appear. It doesn't appear immediately.
Okay,
So when I noticed it, that's when I took the picture.
okay, and what happened after this incident?
What happened
After you were shoved?
after he pushed me?
Yes.
Well, after he pushed me, I said, boy, you got your nerve to put your hands on me again. You don't learn, do you? And I called the cops and it took about 25 minutes for the cops to get there.
And did the police arrive?
Yeah, about 25 minutes later, and the whole time he's yelling at me from the bedroom, calling me names, laughing, thinking he's not getting arrested, whatever. I ended up going on the porch because I didn't want to hear him because that's all I hear every day, all day long.
Do you remember what he was saying?
Nothing I could say in here, just the
You
usual.
can say it in here. It's a court of law, ma'am. If you remember what he said, you have to say it.
Swearing, calling me names, you know,
What kind of names?
I'm lying when I never told a lie in my life,
And
but I lied.
what kind of names were you being?
I don't even remember. I'm so used to this every day in my home. I ended up going on the porch, waiting for the cops to come. They came, they asked me what happened. They went in the house. They called him out of the bedroom. He came down to the end of the hall. They asked him what happened.
And were you present when they were questioning him?
Yes, I was standing in the kitchen.
Okay, do you recall what he said?
Well, what happened was the cops asked him what happened. He said he turned down the radio because it was cat abuse. And then, he told the cops I was lying. And then when I heard that, that's when I opened my mouth. I said, I'm not lying. I don't lie. And they're like, okay, be quiet to me. And then they arrested him. And of course, as they arrested him, you know, what's your badge number? I'm gonna get you guys fired, the usual. They just laugh at them and laugh out, yeah.
All right,
And then, and that's it. And they took them.
all right, thank you, Ms. Martin. Nothing further for this.
All right,
witness.
Mr. Martin, do you have any, let me ask you this first.
Examine the, her arm though too.
You want to what?
Examine her, make sure, you know, it's where the rat supposedly were.
Well, they're not there anymore. She's shown us her arm in court. But I'll have her do it. Ma'am, can you just show your arm again? Where you had.
Where it was?
Where the bruises.
What?
Don't talk to him.
I will stand
Wait,
up.
hey.
No, I was just saying, I'll stand
No,
up.
shh, quiet. Just listen. We're gonna get through this. Lift up your sleeve and show me. All right, see that, Mr. Martin?
Right here. There's
I'm
my
really
arm
careful
hanging,
here.
it was
I
right
really
here.
All right,
not-
thank you, ma'am. Listen, I'm gonna tell you two right now, we're not arguing back and forth. He has a right to ask you questions. Just do your best to answer his questions so we can,
Oh, I was just standing up, I wasn't arguing.
okay, I know, but I'm just, see, like, okay, go. Mr. Martin, what's your next question?
No, before I get to the question, I want to examine the arm closely.
No, I'm not gonna allow you to, Miss Martin, stop. I'm not gonna allow you to go up to the witness and examine the arm closely. She's shown it on the trier of fact. I've seen her arm, I've seen it. What's next?
For the record, I can't see from this distance, sir.
Okay, well, I'm not gonna allow you to approach the witness like
All
that.
right, well, anyway, now the videos, I want the court to review the videos. I don't want to get to that yet before, you know, after the question, whatever, but I want the videos reviewed in support of my arguments now, where the cops entered the house. That's actually only one video, so,
Are you moving for the admission of a video?
yeah. But
Is this a-
when they came in the house.
Is there a body worn camera video?
There is a body worn camera
That
on the
one.
interior of the house.
How lengthy is the video?
It's not that long.
Do you have any objections to the admission of that video?
I have no objection to it.
All right, this is stipulated exhibit 3. If you want to, you can put it on Zoom if you want, if you just wanna. If you're in the Zoom, you could just share screen. And then I can see it and the witness can see it and defendant can see it.
Your Honor, there are multiple videos. If I may ask which one he is referencing to.
I think this is the 5-minute one with the just entering the house. I think there's only one on that. The other ones are.
The
The
squad
car.
car?
Yeah.
Okay. I'll let you into Zoom when I see you. We're a Judge Slavin Zoom today.
I'm still looking for it. Your Honor, may I get the meeting code for Judge Slavin?
Yeah, ready? It's 555-993-6534.
I'm joining the meeting room right now.
Okay. Let me get you in and I'll make you co-host so you can share screen.
Thank you.
I can't make her co-host. Do we still have the
check-in clerk.
Is she still here?
She's on the screen.
All right, it looks like we might have her. Okay.
Okay, Your Honor, I'll be playing this from 00.
Okay. You might have to.
I don't believe it's supposed to.
Mute your audio and see what happens.
I'm already muted.
Disconnect from audio.
What's going on?
Can I say something?
No, she asked if she could say something. I told her no.
That's not from the night.
And she's correct, Your Honor, this is from the 16th. So this is not the video, the 5-minute one he was referencing.
Okay, that's when it violated the bond.
I believe this is the correct video from the 12th, Your Honor. I'm playing from 00.
Okay. Mr. Martin, is this the video you're looking for?
Oh, let's take a look.
Well, no, look on the TV screen. We made it real big so you could see it.
Okay, well, they're not in the house yet.
Well, they'll get there.
I mean, I know you guys. But she likes it, and then she know what happened. I heard.
Your Honor, I believe this is the wrong video as well.
Yes.
But there's another one I do want looked at. Well, yeah, I still wanted to use that one too as a support, but keep going just until my brother gets done saying something in the original stuff. This is relevant to the case. To go ahead, keep going a little bit.
This one's 31 minutes.
If we could skip ahead to the.
Yeah, you want to see what happens, what you want me to see what happened in the house. Is that correct, Mr.
Yes,
Mark?
I'm saying, but Ashley's playing, I just want to go further, keep playing that when you just play my brother, he makes a statement, I just want to go to there, then I'm gonna stop it and then go to that video, but I want to play that when you.
Well, this is the one that's admitted. This is the one you wanted. So let's get through this and then you could try and move for the admission of another video. But let me see that. And just for the record, this is Exxon body cam 6/12/25. It looks like it's hours 22-27-44. So we'll start with this one. And if you want to fast forward it to
And for the record, that's at 1:39.
Okay.
You turn it up, it's way too low.
Can you make the audio any louder?
That's as loud as it's going.
There's no way to connect to the speakers in here, no?
No, because of the feedback.
Do
Do you want me to just watch the videos?
Yeah, if you can do that, then yeah, I guess that would be better.
Can I see the computer so I can see the audio?
Yes, Your Honor.
Or so I can hear the audio?
Video's not already 31 minutes. But
thank you.
Watch these.
This is number 65 today. This man says it's in my house. Push me. I want that usually. Choked me a little. Wasn't nothing major, like I'm not hurt or nothing.
You feel like you're gonna lose consciousness.
No, but I'm like, fucking touch me. Oh, I can lie and say, touch me. I said, I'm a fucking lie. I don't call the cops anywhere unless you put your hands on me. Then, oh, shut up, that bitch. Shut up, that bitch. They knows bitch. I'll do what I want. But like, that's simple. When he walked past it, and I said, oh, I said, I don't know where you got this.
Okay, so he pushed you.
Yeah, because he's also put his hand on my face before. Yes, my dad has never, 50 years of marriage, put his hands on my mother. Yeah, yeah, he's got a rap sheet or tail like this. You guys should know him. You know.
Eric, police. Eric, come out here. Come talk to us, Eric. Yeah, she's just a liar. She's trying to just. All right, what's going on tonight, man? Well, I was turning the radio down, and the kitty girl, the cat, always lays by the radio. I turn it down so she's not doing her cat abuse by turning the radio loud in the ear. She don't.
It was like this. He always says this.
So I just turn it down so it's not blasting her, and she gets all emotional about it, tries to control everything. She lets her emotions go wild. It's usually. Just let him talk. You already talked.
My house.
Bam.
I know.
Outside.
No, I'm trying to get it made all day.
I'm trying to hear this side of the story.
I'm just saying.
Bam.
He touches it 10 times a day.
Stop talking over us.
You want me to get your side of the story?
You sit outside so we can talk. No, I want you, but
yeah.
Trying to get your side of the story. Bam. Anyway, so that's I turn the radio down. She goes wild and crazy, and I sit and tells a lie about. I assault her, and she's telling a lie, and I want to mention, she tried to do this shit before, total lie in court. It is on camera. The judge, prosecutor, for example, she's seen it me before, right? What happened to her? And she lied. That was it.
Never told a lie in my entire life. Okay.
You need to stop.
Just believe I've never told a lie ever.
You need to stop. Right now.
Well,
she's crying out for emotion. All right, you're both concerned. I'm going to put it back. I told you she's not around. You're going to arrest her for her life. That's like that's weird. You're going to get arrested for DV. You can't arrest someone for someone comes to lie. I'm telling you, she lied. Stop talking. What is your name? Officer Beaufort. Okay, you're going to lose your job. Okay.
Yeah, I was just going to lose your job.
You have the right to arrest people.
it's DGB house arrest. No, they don't have to, no, you're violating due process rights. She lied before, and it's on camera.
I've never lied a day in my life, so how can I lie? Patty, you don't get it.
The building's already shut, it's in the court, she lied before. We're gonna take a walk through. What's up? Yeah, it's right here.
Both my brothers are evicted. They should have been out of here 7 months ago. I shouldn't have to put up with this abuse.
He's going to jail tonight, ma'am.
I know he's going to jail, but I just, yes, I'm just sick of them saying, oh, she's lying. I have never told a lie in my entire life. But that's what they both say.
We're not pressing you about that.
I know that, but
What's your first name, man?
Lisa,
What's your middle name?
K-A-Y,
What's your last name?
Martin, M-A-R-T-I-N. Oh, there,
What's your name, please?
good job.
Ma'am.
11/22/69. Oh, he wrote 1,000 lawsuits.
What's a good phone number for you?
734-512-608.
I'm just skipping that ahead.
Yeah, that's,
Second.
that's the part, okay, that's further up as I was
Because
relevant.
he does that, he unplugs my phone line 10 times a day.
That's all you wanted me to hear on that? Okay,
May I approach on?
you may.
Thank you.
And I,
All right, hold on,
okay,
hold on. Mr. Martin, you're cross-examining the witness. So, okay, now you've had me see the video. Do you have any questions for the witness?
yes, but I just want to point out in case, you know, might be doing.
Well,
before.
that's safe
As
for
a-
argument. Mr. Martin, you get to make your legal arguments or your factual arguments at the end of the case. We're in cross-examination. So I've watched the video. It's been admitted. Do you have any questions for the witness?
Yes, I do. I'm just saying I want some more motions to make that, remember,
Okay.
to dismiss.
No, go. Ask her questions.
All right.
Stay right here.
Yeah, Mr. Martin, stay there, but you can ask questions. There's a microphone right there.
I was one of the podium, that's not usual procedure. All right, you made a statement before, true, that I don't know the law. True or false?
True.
Based on what?
You don't know the law. All you do is break the law for 40 years.
So what is that statement based on then?
I apologize for relevance.
It's irrelevant. Next question.
You said the house is yours. You said that several times.
Yes, it is mine,
Your Honor, I object to
but it's not in
relevance.
my name. It is mine. I have the will to prove it.
And I've taken judicial notice that the house and the city of Taylor is under your father's name. Both parties agree to that. So, next question.
Okay. You made the statement that I've been evicted, true or false?
Yes, you
Your
got
Honor,
served.
again, relevance.
How's that relevant, Mr. Martin?
Attack or credibility?
All right, go ahead.
And, well, has any formal proceedings been filed in court ordered by a judge that?
Well, those are two different questions. So wait, if he's gonna try and attack her credibility, the first question was, you asked you asked her what, if she had ever evicted you, right? So let's, wait, let her answer that question, yes or no?
Yes, he was served an eviction from here, you know, you get the paper. He was
Okay.
served it September 17th.
All right,
He was supposed
one
to be
sec.
out October
Oh, next question.
Has the judge ordered me evicted, yes or no?
No, you did not get out October 17th and you haven't left.
Have you filed official paperwork in any courthouse, or this courthouse?
Judge, I don't see the relevance.
Let me just, I'm giving him some leeway. He's in pro per. I don't know where he's going with it, so I'm gonna allow it. Go on, Mr. Martin.
Have you filed any paperwork in court that actually got me, or that caused me to be evicted, yes or no?
Yes, I went to the court window when you walk in and go to the right and got the paper for the eviction, filled it out, handed you the copy. I have the other copy. You were supposed to have been out October 17th.
So did you initially, officially file it with the court clerk, yes or no?
Yes, I got the paper from the court clerk.
And do you have any proof of that, like spam?
You have the copy, I have the original.
But no, okay, well, anyway, so no judge issued an order, you said again, right? No judge issued an order.
No, I did not see a judge.
Okay. I didn't ask, did you see one? Did one issue an?
Well, it sounds like maybe she filed a 30-day notice to quit and gave you notice, but then an eviction case was not brought because you never saw a judge. Does that sound about right? Okay, next question. I got it.
Is it true you said in the videos several times you never told a lie in your life?
That's right.
Now you say I pushed you. How many times did I push you?
You already heard that.
Answer the question, ma'am. No
Twice.
argument.
And where in the body was that supposedly?
Obviously on my arms, since I have a big bruise for 3 weeks. And then the second time, like I said.
Well, the picture's not clear. I see the point in this area around the left shoulder. The other picture's unclear. Where on the body that's supposed to be?
Ask that defense formulate his statement in a question.
Yeah, you have to ask questions. You can't just
I did.
make, you're testifying.
Where is it on the body? Where is it on the body? Besides the other one that's by the left shoulder, I'm asking her, where is the other supposed bruise? What do you call it?
There was only the one.
So now there's one.
All the pictures are of the same bruise.
Okay, I understand. Next question.
Is
Mr.
it-
Martin, she testified that one of the bruises, the first picture was taken on the 16th of that area on her arm. And then she testified the second photo was the exact same area on the 23rd where the bruises were still there. That was what she testified to.
Yes.
Okay, isn't it true that you have been bit by some type of bug causing?
This overruled. Go ahead.
No.
No, she's got a right to do that. She's a prosecutor. She's objecting to irrelevant questions or questions she believes are irrelevant, that she's doing her job. But I'm giving you leeway to see where you're going.
I think they're a little too quick because I didn't hear me out.
Okay, go on, Mr. Martin.
But isn't it true that you've been bit by a bug before, causing you to have a skin condition in your
Yes.
arms?
Scarred, yeah. My arms are scarred. And bottom of my legs. What is that guy with it?
Well, I get to that in argument, but, okay, that's the question. Thinking other questions. Okay, so is it true that, I turn the radio down? Well, you actually admit that, I guess I don't need you to, you already admitted, you turn the radio down. Isn't it true that, Kitty Girl the cat was laying by the radio when I turned it down?
I don't remember where she was at. It's none of your business to touch my radio. If it was on full blast, it's none of your business to touch it in my house.
Just answer the question. Do you remember the cat being by the radio, yes or no?
No, I don't
All
remember
right,
the
next
cat.
question. She doesn't remember. Next question.
It was on volume 2.
No more. Next question. It's
Thank you.
irrelevant. Quite frankly,
I
whether or
know.
not the cat was by the radio means nothing to me as a trier of fact.
Oh,
Next question.
He knows the law.
I'll
I
get
know,
to that, how it is
but
now.
you don't know how to be quiet and answer questions.
I'm answering them.
Ma'am, do not respond to me again. If I ask you to answer the question and then quit talking, just quit talking. Next question.
You have a receipt for the radio since you allege it's your radio.
Irrelevant. Next question.
I object to you saying it's relevant because.
I don't care. I'm the judge and I said it's irrelevant. Next question.
Is it true that a case was dismissed before where you testifying that you never saw it?
That you never what? I just didn't hear you. I just
asking her, has a case been dismissed before with me that you tried to bring against me, alleging I attacked you? And I asked you, did you swing me before? And you said no. But the judge has seen on the video that wasn't true.
Judge, I'd object to relevance on this as
Oh,
well.
I can explain that.
All right, well, I don't know if it's relevant or not.
It's not.
I mean, does it go to her credibility? Maybe. So I'm gonna go ahead, explain it.
I've never swung at him, for one. This video he's talking about, the first time that he didn't put his hands on me, he kicked me in the stomach back. And I called the cops. We had a Zoom meeting with Slavin on that. I couldn't do Zoom at that time on my phone. My boss let me do Zoom on hers while I was at work. I went in the conference room. I let them know that this phone's gonna die any minute. They said, if it does, call this number back. So as he was representing himself again, asked me a question, something, the phone died. I called the number right back and they said, the judge dismissed it. I said, how? He kicked me in my stomach for no reason.
Okay.
And they said he showed a video to the judge. Well, there's no video of me ever coming at him. So what he showed, he basically committed perjury. He showed a video of years ago when he grabbed my wrist so hard and I had to fling my arm like loose. That would be the only video that he could have shown Judge Slavin
All right.
for him to dismiss it.
Okay.
That had nothing to do with him kicking me in my stomach of what the incident was about.
All right, Mr. Martin, next question.
Is it true that, after I turned the radio down, that, you went to my room, getting in my face?
No, I didn't even walk in the room.
Wait, okay, that was her answer. Now, what was your next question?
Did you, go to my room after that? Told me he was gonna go to my room, invest with something in my room after I turned the radio down. Did you do that?
I didn't even go in your room, which is really my room because it's my house, but no, I was on the outside. You said, get out of my room, charge toward me, and that's when you pushed me.
No more questions I can think of right now.
All right, any redirect?
Just one question. Ms. Martin, could you have gotten that bruise any other way?
No.
Okay, you
I
wouldn't
never
have
left the
hospital or
house,
anything?
never left the house, didn't even vacuum out, think of them a couple days, no.
Okay, nothing further.
Okay, so witness, do you have
Excuse me, yeah, just
recross?
some
Okay,
more questions, just.
go ahead.
Sorry, but, isn't it true that you smoke cigarettes every day?
Objection relevance, Your Honor.
How's it relevant?
As to, so be my argument, how she's partially suicidal by smoking cigarettes, and this is why
Okay,
she'd be willing to
No.
mark herself up.
no. Sustained. Next.
So the next question will be along the same lines of that, if you're not gonna allow that, then the others do the same thing, so. That's all I can think of right now.
All right, can this witness be excused? Do we have any further questions for this witness?
No, Your Honor.
No questions.
Okay, ma'am, you're
Okay.
excused. Thank you.
And the people rest, Your Honor.
All right. To prove this case beyond a reasonable doubt rests solely on the prosecutor. Do you understand that?
Comprehend that.
Okay, and you understand that I could not use your silence against you in making a decision on this case. Do you understand that?
Yes.
So that doesn't matter one way or another to me. I would not consider whether or not you testified or whether you didn't testify when making a determination in this case. Do you understand that?
Well, I understand, I don't have, well, I can comprehend, I don't have to, but I don't know, I don't agree maybe with the legal aspect, whether it's.
Well, you don't have
Has
to
to.
agree with it. I'm telling you,
I'm
as a
saying by
judge,
law, I understand.
I just need to make sure you understand that I'm telling you, your refusal to testify would not be used against you. I would not consider it. Do you understand that?
I comprehend that, yeah.
Okay. And are you waiving that right to remain silent and testifying in this case?
Yes.
Okay, Before we take your testimony, do you have a motion for directed verdict or a motion otherwise?
Yes, but you know, there's an issue of kind of evidence I want to get to kind of support the case too. And I, you know, being in jail, I don't have access to it, and now the lawyer's not doing his job, so now.
Mr. Martin, you had a bond condition. I want to be clear on this. You had one bond condition that you would not follow. I told you you could not return to that residence while the case was pending. And you continued to go back to that residence. And you violated the conditions of this court. And that is why you were in custody. So let's be crystal clear. The reason you had a personal bond. I let you out. And you refused to comply with the conditions of my bond.
I had nowhere else to go to neither.
Well, that's not a me problem, sir. I'm telling you, the reason you were in custody, solely the reason you were in custody is because you would not follow my bond conditions. So you took away your freedom because all you had to do was that one thing and you couldn't do it. So let's be crystal clear on that. Now, did you have a motion?
Yes, I have some, yes.
Your record.
Move to dismiss based on, well, the police officers due forward is not here, and the other one, I move to dismiss on that. My right to cross-examine is violated on that because they're not here, so. Tort, Dylan, and Jeremy Duford, they're not here, so.
Okay. Anything else? The prosecutor has a right to prove her case as she sees fit. And if she wants to bring in a complaining witness and prove that through the testimony of one witness, she's entitled under Michigan law to do so, or any law in the country. So that motion's denied. What else?
Well, I have a response to that. That's true as what her right might be, but I'm saying my right to due process is being violated. So it's irrelevant to my right to be violated.
Okay.
Cross-examine.
You made your record. What's next?
Next one is, under, I move to dismiss under MCL, it's the 28.6B. You want to pull it up, you can refresh your number.
Thank you. I will do that. Go ahead.
It's like section 1. If I remember right, I think go to section 1. I was just looking the other day on the tab of the jail, and I had to hurry up and turn it in, so I have a chance to write it down. I'm pretty sure it's section 1. At first, the police is their limitation on arresting. And it mentions, I'm pretty sure it's section 1, where it says they shall not arrest basically unless, if they're not aware of a crime being committed right in front of them, they're not supposed to be arrested.
Okay.
So they shouldn't have arrested under that statute, and therefore since they shouldn't have. Now, well, let me ask you before I get to the rest of my argument, do you see where it says that in section 1? Or 2? It's not much reading, it's right under the, you only have to read all the heading and all that, just right when it gets to the text of the statute. It's referring to police as, like I said, the limits on arresting. They may arrest only in felony cases or if a crime has been committed in their presence. That means they know for sure. Otherwise, they shall not arrest. This statute supports that. They did it anyways, so therefore, I've been illegally arrested.
Okay, I see the statute. I've looked at the statute, and that motion's denied.
I'd like to know the reason.
Okay, Mr. Martin, well, you can appeal me.
I will, and actually, I want to get an appeal form for the request.
Okay, well, we got to find out what my ruling on the case is before you do that. But any motions or that you've made that I've ruled against you on, will you potentially can file your motion on those, and we'll make sure we address that. But I'm still taking evidence.
All right.
Anything else?
I don't think so. No.
All right, Mr. Martin, you want to come and take the witness stand? Stand and face me, Mr. Martin. And raise your right hand. You understand you have a right to... Sir, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, have a seat, Mr. Martin. And he does not have an attorney, so I'm going to allow him to just give a narrative, and then you can cross-examine on that narrative. All right, Mr. Martin, go ahead. What do you want the court to know?
Start off, my sister she's a constant liar.
Okay.
She's very aggressive,
Okay.
psychotic, and to a degree.
All right, is there anything you want to tell me about this instance?
Well, first we'll start with the general, then we'll go to specifics.
All right, well, that's character evidence and it's not admissible, so it's stricken. Go ahead.
And I object to that because it's relevant to the credibility.
Okay, it's not. You're talking about her aggressive behavior, right?
Excuse me?
You're telling me she's psychotic and very aggressive, and that really doesn't go to her credibility. That goes to.
Well, the end of me arguing to see it. but
All right, what's
Well, I get-
next? What else do you want to tell me?
That's reconsidered after I do my argument.
Okay,
I'll point out it's relevant.
all right.
I wouldn't say things that's not relevant, so even though I'm not an official attorney, I don't have their official training. Studying and practicing law for 30 years, I know it's relevant.
Okay, all right, go ahead.
So basically, on the day in question here, it was relevant to the complaint. Turn the radio down because she had it too loud. The kitty cat was laying right there by the radio. She had it at an uncomfortable level, turned it up, it was too loud. I turned it down in consideration of the cat. It's not stressing the cat. And it wasn't no volume, like low, real low, or too, like she says, it was loud and at a comfortable level, so. I do it, she gets all crazy and emotional. You're not gonna be turning my radio down, and turn it back up, I'll go in your room, mess with it. So I went back in my room. As she said, she was going in my room, mess with something, so I go in my room before.
Wait, what? Who went to the room first?
I went to the room first.
Okay, and then what?
I mean, after she said it, so she already gave me indication, going in the room, mess with something in my room, so I went in there so I could see, so she ain't doing something I can't see, but. So then she followed me in there, like right at the doorway, she came in behind me. And, then she's standing right there at the doorway and then still shouting, you have to turn my radio down. Whatever, this is my house, and just getting all emotional and crazy, but that's it basically. And I just turned around and said, get out of my way. She was just blocking my way, but she was all in my face, and trying to instigate me to do something to her as she normally does, as she did in the last case, which is why they dismissed, they seen on the.
All right, I don't care about that case. Keep going.
Basically just getting aggressive in my face, and I told her to get out of my way. She wasn't moving, trying to instigate me to assault her. But I didn't do that. I just, I had a little leeway, like between the wall and where she was standing. She was standing to the left a little bit, so I just turned my body like this, and since she wouldn't move, I just went aside her, and I didn't push her or do nothing. I went alongside her, behind her, and went to the refrigerator, and that's basically it.
Go out in the hallway. Go in the hallway. Yes, you, go in the hallway.
Yeah.
Go on.
I listened to all this lies.
All right, go on, Mr. Martin.
That's basically it. I went to the refrigerator, and that was basically it. And then I went to my room, and she called the cops, and that's it. That's pretty much it. And, like I said, basically she lied and didn't do it.
Anything
They grabbed
else?
her, nothing.
All right, so your testimony is you didn't push her, you just walked beside her?
Yeah, slip, like turn my body like this, but I mean the way she instigates someone, she instigates people to do stuff like that, and then she wants to act like she's the victim, but that's not true. And as her own testimony, I want to say admits.
It's not argument, just tell me what else happened or whatever. All I want to know about is what happened that night.
Yeah, that's all I have to say that happened that night.
All right, cross.
Thank you, Your Honor. And Mr. Martin, to start, you do understand that you're under oath and under the penalty of perjury, correct?
Comprehend that?
Okay, and yes or no answers if you could.
Yes.
Okay, and you and Lisa Martin are siblings, correct?
What's the word sibling?
Brother, sister.
Yeah.
Okay, and were you both, on the date of June 12th, 2025, you were both at the location 9074 Clipper in the city of Taylor, County of Wayne?
Yep.
And that's your home?
My home now, well, it's our father's, it was our parents' house.
Do you live there?
I live there, I've been living there all my life.
And does Lisa live there?
Yes.
Okay, and on that day, June 12th, did you and Lisa have a verbal disagreement?
Verbal back and forth, yes.
Okay, and was it about a radio?
Yeah.
Okay, and would you agree that that argument got heated? Were you upset?
Stuff, I mean, back and forth, I'm not sure about the set part, but verbal back and forth, maybe a little bit, you know, but nothing to the degree gonna make me salt her. I know that's what she wants. I know she's gonna call the cops anyway, so I know there's no sense in
Okay,
doing that.
and so you're stating no, that it wasn't heated?
I guess every argument maybe to agree might be slightly, but I'm not gonna say it was really heated, you know, I mean, no, I mean, maybe a little bit, you know, but not really, no.
Okay, and was your tone, was it raised?
It was maybe slightly, not too much really, but.
Okay, and you're denying that any physical contact occurred with you and Lisa Martin?
No.
Okay, and you're stating at that time that you were inside your bedroom
Yes.
and Lisa was by the doorway?
Doorway like in my room, just barely though, but just like 1 foot inside the doorway. And I walked away a little bit and I just turned right around.
And do you know how big that doorway is? Is it wide, is it narrow?
I'm not,
Is it a regular house doorway, Mr. Martin?
yeah, it's regular.
For a bedroom? I
Ain't no
saw the
mansions.
pictures of the door and the,
This ain't no mansion, so. But she was standing to the left, right, just had enough to get by her. Plus, I'm a small guy, I can, stand to the side and I can get by, you see, I'm a pretty skinny guy. I mean, only 140 some pounds, I'm telling you, which for me to get through.
Okay, and Mr. Martin, you're stating that you never touched her at any point?
No,
You never, even walking past the doorway, didn't accidentally hit her or anything?
no, she wanted that to happen, was standing in the way, but I had enough way to get through and, no.
Okay, and you heard Miss Lisa Martin testify. Do you disagree that this incident took place?
Her testimony is a lie. The only thing she told the truth was about the radio. I turned the radio down.
But you're disagreeing with what she testified to today, that an assault occurred?
Yes,
Okay, and you're maintaining that today?
yes, and I don't agree that, I'm also testifying that these they look like blotches on the skin. That ain't caused by no finger pressure. That's.
But you're maintaining that today, right? That didn't occur?
Right, yes.
Okay, and one moment, Your Honor. Mr. Martin, at any point in your life, have you ever been convicted of a crime of dishonesty?
Fraudulently assumed, so yes.
Okay.
was that within the last 10 years?
No.
No, Your Honor. Okay. I have nothing further from Mr. Martin.
I have some more things to say.
All right, well, if there was a crime of fraudulent activity and he did testify at some point that there was some crime of dishonesty in his past, it's past 10 years according to both the prosecutor and the witness. So I'm not using any of that testimony in making my decision. Mr. Martin, go ahead.
Yes, also want to say now, the main reason why my sister, keeps up with this agenda of telling constant lies against me, trying to get me with these domestic cases. is because she has this agenda trying to take over the house for herself. Hoping the cop would be dumb enough to arrest me like they was. No probable cause, no evidence, just based on her word. And this is the agenda why she's doing it. And then she even had her daughter try this on me too, which that case was dismissed too. This is why there's no evidence. And she knew when I reminded her of it, you know, by the law, you gotta have evidence, you gotta have not just your word, it's not evidence.
Well, your testimony is evidence, Mr. Martin, so.
Well, I said, but
And that is, the jury instructions tell me that I can convict based on the testimony of one witness, so I'll follow the jury instructions. But go on.
no, but that's no more than my testimony.
That's correct, sir. You're absolutely right about that.
So, but yeah, so her daughter had tried the same thing, that case was dismissed, so they both try to conspire with each other.
All right, I'm striking all of that. None of that's relevant. What else, Mr. Martin?
I'm just gonna say that's their agenda, that's
Okay, I understand
That's my
that.
sister's agenda.
All right, Mr. Martin, anything else? All right, are you done?
Yes, Your Honor.
All right, Mr. Martin, you can have a seat. You have anything else you want me to consider?
No, that's what I'm trying to think, I don't wanna rush and then forget something unless I'm trying to.
Well, that's all right, Mr.
Right.
Martin. I think you covered quite a bit here. So you can have a seat back at the stand or at the defense table. All right. And Mr. Martin, are you resting at this time?
Resting? What does that mean?
Well, do you have any more witnesses that you're calling?
Oh, okay. Well, no, I wanted it first, but no, since you questioned her on it, it's not necessary. I was gonna, like I said, the tax assessor, but that's good. I'm glad you covered that. I don't need that now, but, let me think,
Mr. Martin, you don't
oh,
have.
the other video. That's right. It's just reminding me.
All right, Mr. Martin, you can have a seat. Just have a seat. I'll accept that other video, but your brother's not here to testify about that, okay? And I don't really think it's relevant. Do you have a closing argument?
Yes, Your Honor. Start, Your Honor. Today we're here for assault and battery charge, domestic violence count against Mr. Eric Martin. We as a people believe that we have met the burden beyond a reasonable doubt for these charges here today. We did hear testimony from Miss Lisa Martin. This is Mr. Eric Martin's sister. They both reside in the same home. That a dispute occurred over a radio on the date of June 12, 2025 in the city of Taylor, County of Wayne, location being 9074 Clifford. This is both these individuals' home. Miss Lisa Martin testified at some point this after a radio was turned down, she approached Mr. Eric Martin's room. Eric Martin he stated to get out of her room. He shoved her once and then attempted to shove her again, but hit her neck the second time. This was unwanted contact by Mr. Eric Martin against Lisa Martin. The testimony believed our witness, Miss Lisa Martin, to be credible. At no point did she change her testimony or change the story. So we believe that we have met our burden today and ask that you find the defendant, Mr. Eric Martin, guilty.
All right, thank you. Mr. Martin, closing arguments.
First of all, the witness is nowhere near credible. They have no credibility at all. As it was evident today by reviewing the video, that my sister made comments several times, it's my house, it's my house. But yet, as she admitted to the judge, the house is not in her name. So it's not her house. That's one lie right there. She's a liar. And her other statement was in the video. I don't know the law. And as she admitted it today in court too, I don't know the law. That's totally baseless.
All right, well, Mr. Martin, she's not charged and you're not charged with not knowing or not knowing the law. This is a domestic violence case.
I realize I'm saying as to her credibility. This is a lot.
Okay, well, Mr. Martin, you didn't go to law school. I don't care if you're personally insulted by your sister saying you don't know the law.
No, I'm not insulted. I'm saying this goes to her credibility.
Okay, well, it doesn't. It doesn't. Because you don't know the law.
Obviously, I made reference to NCRs in here, how my
Okay.
chart.
Anything else, Mr. Martin? Are you ready for my ruling, Mr. Martin? Because I'm ready to rule.
No. Like I said, I got more relies to point out.
Oh, okay, well, you don't even have to. I'm gonna make my ruling, all right? The prosecutor has the burden of proving this case beyond a reasonable doubt. It's the highest standard in criminal law. It's like 96%. The jury instructions tell me I can convict based on the testimony of one witness. Jury instruction addresses that, but I also have to consider jury instruction 3.6 on witness credibility. And there are factors I'm to look at when I determine whether or not I believe a witness is credible. And those factors do not weigh in Miss Martin's favor. There's no doubt she had a memory. She was consistent with her story to some degree, but she evaded questions. She argued with this court. She argued with the prosecutor. She argued with Mr. Martin. I had to tell her on multiple occasions to be quiet. Ultimately, I had to remove her from the court for her behavior. She has no self-control. That was abundantly clear to me. Mr. Martin has appeared in front of me many, many times at this point, and he's a handful and he's frequently disruptive during court proceedings. That doesn't mean that I'm going to take all of that into consideration when I'm determining whether or not someone is guilty of the charge of domestic violence beyond a reasonable doubt. There's no doubt in my mind that people have personal interests involved in this case. And here's the reality. It's very difficult to prove a case based on the testimony of one witness, especially when that witness is argumentative to the extent that she has to be removed from the courtroom. That's just the reality of the situation here. And Mr. Martin, whether or not I agree with him 99.9% of the time, is not what the issue is here. The issue is whether or not the people have met their burden of proving Mr. Martin committed a domestic assault beyond a reasonable doubt. And based on the jury instructions, based on the testimony that I've heard today, I do not believe the people have met their burden. And the case against Mr. Martin is, my verdict is not guilty. Anything else?
Thank you for your just decision.
Well, Mr. Martin, that doesn't mean I think I agree with you on most things, but you don't have the burden today. And that's my ruling. We're all set.
Thank you.
Thank you.
I'm totally fine. Like, love it, love it, love it. Can I ask why?